we are obliged to start this session. I think it's going to be a very good, thorough deliberation on various intricate issues involving government hospitals. I am Dr. Kohli. I am basically a surgeon into medical legal practice and medical administration.
I am Pratiksha Mishra. I am an advocate practicing in the Supreme Court with practices in consumer court and various other tribunals in Mumbai.
There are 4 issues given to us by the organizers. We will take up one by one, and in case there are any other issues emerging from them, we'll take them also, and we'll note down the important recommendations, and we'll have deliberations. So the discussion can be, from any side. There's no any particular pattern of speaking. Anybody who has strong views can start off, and others can give their inputs. So to start with, let us discuss about the government hospitals and institutions. Should they or should they not be covered under the Consumer Protection Act? We are all aware of the landmark judgment of the Supreme Court, where it has not differentiated government and private hospitals vis-a-vis the Consumer Protection Act if they are charging fee from some or more patients. So what are your thoughts on whether we need some improvements, some amendments in this legislation?
So before starting, can I request one thing? Can we have an introductory?
Yeah, sure. Maybe you can start on this side.
Exactly, I'm a practicing lawyer, and I retained my customary college Bangalore and other institutions to conduct their cases.
Dr. P.K. Ratna, orthopedic surgeon from the General Hospital, Delhi.
Good morning, everybody. I am Dr. Shailesh Moide, Professor and Head, Department of Forensic Medicine at Mumbai Medical College.
I am Dr. Pratik Rathi. I am Special Executive Officer working with Employees State Insurance Scheme Maharashtra.
This is Dr. Vinda Singh, as Public Health, very government from the world.
Myself, Dr. Jayapal, I am medical student from the Government Hospital.
I am Dr. Monica, HOD Dentist from the Government Hospital.
Good morning, I am Dr. Veer Sagar, physician at the GP Hospital.
Sir, I am Dr. Kuntal Mishra, Medical Minister, Medical College Hospital, Kolkata, the Guardian Institute of Ishtar.
Good morning. I am Alishita Banerjee. I am Medical Secretary and Vice Principal of Medical College.
Good morning, I am Dr. Manju Banerjee. I am the Director at PGM Nagpur.
I am Dr. Praveen Chilwale, Director of Medical Education, Government of Maharashtra.
I am Dr. Anil Sen. I am Krishna Deputy Director General in the Ministry of Health, Government of India.
So we can start
सर आपने जैसे कहा ना कि चार्जेस ले रहे हैं तो हमारे सिंस हमारे हॉस्पिटल के गवर्नमेंट हॉस्पिटल वी आर ओनली चार्जिंग रजिस्ट्रेशन फीस 5 rupees 10 rupees per day.
The court has in the judgment said that if it is only a nominal registration fee,
Only
that can be excused. But if you are charging for the maybe the private hospitals or the procedures,
no, we are not.
After diagnostics, if there's anything that's
No, they are free of charge.
that's free of charge, then it's not under the ambit.
Even the diagnostic, they are nominal charges. For example, we are charging only 500% university. For university, charging only 100 rupees. They are the nominal charges.
the court has specified nominal registration charges. So we have to deliberate on whether that needs some amendment or improvement. The court has suggested that if there are nominal charges for registration of the patient, so that can be excused. But otherwise, if you are charging anything from any number of patients, then you come under the ambit of.
So what will be the definition of nominal charges according to the court?
That's open to interpretation again.
Sir,
Sir, actually, in the CP Act, sir, you can never to say this thing. The definition says that government hospitals are included on the aspect of service.
Yes.
So, from the service category, whether the patient is paid or not, that is not the case. But it is the category of service for which government hospitals are included in this.
Right.
Now, in their modifications and their discussion in the parliament also, probably, sir, you can highlight, give some light on this thing. Here, we have to look after all the patients who ever coming to our hospital. So there will be a standard of guideline. And now only a few years back, government has come out with this public health standard for the primary health center to district hospital, not for teaching hospitals. If the person is to be given the service for that category, that has to be done by the government itself from the administrative hires, not from the bottom level. And when the patient is coming, then we have to give the service, whether we are able to do or not. As per WHO, a doctor is entitled to see throughout the day 40 patients, but we have to see about 200 patients, more than that. And in the time of any accidents, like any flood or any other accident, we have to treat all the patients. And the CPA is applicable for that. For these things, we suggest that government hospitals should be kept under the outside this.
Excellent.
but can efficiency of service on account of large volume of patients, can that be justified? How is the patient
So
concerned?
the liability of, I think, private doctors and government doctors are something that should be entirely different because they're working in different setups altogether. There's lack of infrastructure. Per patient, a doctor that is handling, they have no other option. They're trying to give the best of their services. So I think the definition of what reasonable care is in such cases have to be interpreted by the courts per se. Because as per the Consumer Protection Act, rendering of service comes under the Consumer Protection Act. So under government hospitals, when you're taking whatever kind of charges there are, you're rendering their service. However, I think that's where the industry of doctors we need here to come and help, because the kind of responsibility that the government hospitals, doctors at government hospitals are rendering is something entirely different from that in private sectors. So that's where I think there's a gap in between the law and what's practically happening in these places.
Maybe if I can understand the sentiments, the rationale should not be related to whether the patient is paying or not. It should be related to the nature of services being provided. So we can differentiate government hospitals from private hospitals. And even if in the government hospitals patients are paying for their operation fees or whatever, they are going to be nominal. They can't be as exorbitant as you have in the private. So maybe if we can agree on this, that it should not be related to whether the patients are paying or not, it should be differentiated private from government. Then what about the so-called charitable hospitals?
So then we are basically.
When we have decided that charges should not be the criterion.
Yes, sir.
So if charges is not the criteria and you are telling about that rendering of services is the criteria, it should be taken as a criteria. Then sir, rendering of services cannot be different between what a private hospital is doing or what a government hospital is doing.
You can't have
Except that again, we are talking of numbers, we are talking of the quantity. If a private hospital has to have around 100 patients in total, we are talking in the numbers of thousands.
What if a private hospital also has large volumes?
Probably not. It cannot be comparable to the government hospital or government college.
You can just they are listed, but you are in the last, but government hospital we cannot try. We cannot go every day you are in a vetting district, you are not in a vetting today. If the specialist can any bit from the reference to the government sector, no, we have large
So we cannot take it as a rendering of service to be included in the as to be the person becomes the patient becomes a consumer.
Should we mean that the service provided to patient will be A class in some set of hospitals and B class in another?
No, that cannot be. That's what I'm saying. So rendering of services is equal.
The question of Consumer Protection Act is related to the level of services. There should be no negligence, there should be no deficiency of service. So are we justifying deficiency of services and negligence in government hospitals because they have large numbers?
No, I think it's not justification. However, we have to see from the point of view of doctors also. At the end of the day, they're not machines that can operate 24/7 a day. So I think this is where the industry is lacking. Government has to pump in more doctors, more infrastructure for government hospitals. However, till then, there's something that has to come in place to aid the doctors in dispensing their services. Because tomorrow when the liability comes onto them, we need to understand that the kind of resources that they have are not equitable to that in private hospitals.
See, when a government doctor is implicated in a consumer court, the liability comes on the vicarious liability comes on the government, not on the doctor. So government has a lot of funds.
No, sir. No, sir.
The patient is
No, sir.
admitted. That-
It's directly to the doctor.
It's to doctor and hospital.
And the hospital.
No, if it
No,
if it-
sorry. Mostly, because like what he says is correct.
No.
Very rare cases only individuals are.
if it is
Sir, I think underneath the statistics, there are already 4,000 cases against the hospitals, of which government hospitals is about 200, 800, of which the doctor has been accused in most of the 2,500 cases.
Sir, before the consumer court or civil court? You mean
Consumer court.
consumer court?
Consumer
court.
Can you sure?
Yes, sure.
I am putting this thing.
Not only that, in our hospital particularly, we are having a case running where the
If we-
3 doctors individually are charged plus the hospital.
that could be some difficulty in the presentation of the case before the court maybe. So can we put a recommendation that in a government hospital, if there is a liability, it should be squarely on the government as the employer, not on the doctors?
That is there.
Sir, but that is the
Some
issue.
is concerned, if some lack of services because of infrastructure, that can be due to the administration. But if it is because of the competency of the doctor has failed to use his student knowledge, then I don't think that administration is to be blamed for it. Even administration say you catch the illness. If orthopedic surgeon has done wrong foot, you catch the illness.
But it all boils down to the system. There has to be a system of checks and balances.
But that system of checks and balances should not be different for private and
But
government.
then at the end of the day, we
If
have
you
to
have a
realize
checklist,
What about the
then
liability? I mean, if the doctor is not provided the adequate support systems. And
like a senior doctor at a private hospital is say monitoring 10 surgeries. At a government hospital, he's probably monitoring 50 surgeries at one time. So obviously there.
no, it doesn't happen like that. 50 surgeries at a time.
I'm just giving you a
She's giving a
example. I'm just giving you an analogy.
She says, I'm giving a comparison. Take it to 1 in 5. Take it as 1 in 5.
Government doctors cannot be placed on par with private hospitals. They are having workload like 10 times more than the private. Number one. Number two, in private they regulate by admission fees, appointment, etc., etc. Unless you get an appointment,
Market
you
forces.
cannot go there. But in a government hospital, it's a mob, and you cannot negative them. It's a law and order problem also comes.
So-
Suppose something goes wrong, so there is a mob of people.
So in that kind of an environment,
Yes, sir.
if you see a surgeon or a doctor is also a human being, and he can make mistakes. So
Who considers
He
that?
cannot reject
He
it.
cannot make a mistake. He should not make a
he should
mistake.
not make a
He
mistake.
because of
He should
his,
not make a
he
mistake.
should
So
not
that's
make a
an
mistake.
infrastructure problem. It's a hard infrastructure, it's a
Yeah.
soft infrastructure.
Sir, may I just refer to one study of WHO on AIDS, that is from very recently. Here, if the workload for a doctor, per OPD is about 140 to 150 per day. So they are giving, this doctor cannot give proper service to that person, but he has to make all the diagnosis, provisional diagnosis and give the treatment. But he cannot satisfy all the patients because lack of time. So, in the many of the cases, the CPA are being charged against the doctor because they have not given adequate time to the patient. So, if CPA is there, what the doctor will do? See 40 patients in the OPD or see 200 patients in the OPD. I can't give any patient who is coming to my OPD without giving him the right advice.
So let's deliberate on this proposition that in case there is some negligence or deficiency on the part of any employee in the government hospital, be it a doctor, consultant, RMO or nurse, the liability should be squarely on the government. Any issues with this?
No, sir.
Squarely on the individual. If it is personal negligence,
Yes,
it should be,
Individual.
it has to be on the individual.
And some
If, as I said, in case the surgeon has operated on the right foot and the pathology was on the left foot, it is on squarely on the individual.
See, if it is because of the lack of support system.
Then it is vicarious liability. Then it is vicarious liability. But if there is personal negligence, if a doctor has not used his prudent knowledge as an ordinary person should have had done at that point of time, then it is almost personal negligence.
I would like that, sir. Except res ipso liquiter.
Maybe.
Except res ipso liquiter, all the cases should be borne by the state.
Yeah, then the concept of vicarious liability would be.
That's the law. They
What
may
is
accept
the
that.
test
Or
of
maybe
test
we
of,
say
personal
it will be vicarious liability on the government, except in exceptional circumstances where it is outright negligence on
Yeah.
the
On the
part.
part of the concerned individual, whether he is doctor, nursing, means
Whoever
anybody.
it is.
Sir,
But
but
this
this can be
I want to
by the Medical Council Act itself. The ethical committee of the Medical Council can judge whether the doctor has done the proper thing or not.
Medical council, let's keep that separate because this had nothing to do with Consumer Protection Act.
Yeah.
I'm talking of Consumer Protection Act. So, and even otherwise, Medical Council Act is on the amendment side.
Yeah, it's
So
under-
let's keep that away. Specifically talking about Consumer Protection Act, if on the government side, if there, because of the so many problems which are beyond the control of the doctors, and even the government is not in a position to rectify those issues. So if in this circumstances some Consumer Protection Act liability comes, that should be borne by the government, except in exceptional circumstances where it is outright negligence on the part of the doctor.
So who will judge this? Who will judge this negligence?
Exactly, coming to that, Consumer
Because
Protection
court is not
Act
expert.
is a quasi-judicial tribunal. Such clear evidences cannot be led at consumer court. So again, the test of personal negligence versus the hospitals or institutions liability, such things can only be judged at the civil court. How do you go to consumer court? Because consumer court is not it's a quasi, it's basically an arm aadmi's court. They don't go to the intricacies of evidence there.
Generally, there is a
But
department.
for medical cases, it has to go to some committee. Dr. Shingari would be
We have a different system in the state of Maharashtra regarding this. We accept as a state government the total responsibility of the whatever consumer court orders are there against the individual also. The state totally accepts the responsibility. Now, once we accept the responsibility, then we set up a committee of the experts related to that field and that subject. The committee gives the report that whether it is the burden over the doctor or the law infrastructure or what is said the operator of the law. So then on the basis of that committee report, then we either recover the amount from the doctor's salary or we suspend the doctor.
That is a
That is what
The department.
That's the department.
It's not judiciary, it is department action.
That is the department.
That is what we can do is we can give such kind of a recommendation that when a consumer case is initiated against a doctor or an institution, such a department should also be included in such cases and they should also give their recommendations.
I think right now the provision is before going to the consumer now, because a lot of medical cases are going in consumer court because of various reasons. The court has asked for a committee in opinion of a panel of doctors to verify the veracity of the case and then come to the court. So that system is in place right now.
That is not in
That's
place.
not how it
That is not in
No,
place.
because when a patient has a problem, we directly go to consumer court. He won't go to.
He doesn't go to court, I expect to.
I think you are talking of what is
Decide,
the
if they are non-medical people, how does the court decide whether there is an element of negligence or no?
Correct,
So
that's
it is
where.
by expert evidence, so what Shingari sir said, that is expert evidence of a board constituting members of that particular faculty, say anesthesia, dynamic, orthopedics, whatsoever the case is related to. So the courts, at least in Maharashtra, go by whatever the expert committee says. The doctor also has an option to bring his own expert also if he feels that the opinion is a biased one. That is the
That's why
scenario.
if the VP Shanta case wherein free services were, when free services by government hospitals were excluded under the Consumer Protection Act, They deliberate upon whether the technical member in a consumer tribunal is competent enough to say to these cases. Wherein it has been held that in case the tribunal feels that such cases involve great questions of negligence which has to be tried in an intrinsic manner, those will be referred to a civil court and not the consumer court. That has been already taken care
The
of.
issue can be raised before the court itself.
Before the
Should we taking one point ahead, we had the judgment Martin D'Souza. So if we can seek an amendment in the Act itself that all medical negligence cases should be first screened by a medical committee.
Yes.
Before it is admitted in the court.
Yes.
So at the admission stage, there should be a screening of medical negligence cases.
That was there.
By
It was
a-
overruled.
That
It
is
was overruled.
In fact,
This suggestion was given by Martin.
Yeah, but it was overruled by the Krishnara.
Yeah.
So we can have it in the Act itself.
Yeah. Yes.
That
Yes.
is have, blanket, you compare the government hospitals with the private hospitals. I don't know where the numbers are going to shoot up. Such cases, lower pressure cases which we have now, and if we include all the government hospitals right up to the PHC level under this ambit of CPA, the number of cases which are going to come before CPA will be enormous. There will be any number of people instigating people to go against the doctor in CPA, under CPA. So it's going to be a problem for the judiciary also and for the consumer courts also. If you equate the government hospital with the private
They cannot be equated. They cannot be equated. I get your point. As we decided that charges should not be the criteria. Government hospitals are not charging at PHC level.
Sir, just I want to come in over here. Because I belong to ESIS. ESIS is a totally different scheme wherein the employees and employers they contribute a percentage of wages, and that is deposited in a fund, and from that fund all the activities happen, including payment of salary, procurement of drugs, providing all services, and taking care of infrastructure. So basically what is happening is the consumer is putting in his money, he's paying an insurance premium, it's an insurance scheme, he's paying an insurance premium, and for that premium he is being provided this service. So this matter has gone up to Supreme Court from National Ishwari Lal case, and the Supreme Court has delivered a judgment that all such patients, IPs, insured persons, they are entitled to be covered under the Consumer Protection Act. So within the, this is one of the verticals of the government, the public health system, the medical education, and ESIS, CGHS, railways. So ESIS is totally covered under Consumer Protection. There it is not gratuitous, nothing nominal, nothing. It's an insurance scheme, so it has to be treated, means somehow, even if we make some recommendations, it is basically has to be treated as an insurance scheme and will have to be equated by other insurance players who are providing medical care services in the market. Though it's a government, it comes
They
under.
are paying, the clients are paying for the services.
But here, again, the problem is the central government is collecting the premium and the healthcare is provided by the state government.
So how should the PHCs be excluded? Like Dr. just said, PHCs they are not charging anything. And if we don't have charges as a criteria for exclusion, then how will we be able to exclude PHCs?
Just to continue this point in regards to this user fees, we talk a lot about user fees and that being the basis of the contract, and that's why the person, in case if somebody is feeling short of service, going to the court of law for seeking justice. Now, after NHM came into picture or NRHM came into picture, they had established Rogi Kalyan Samithis in our hospitals. And basically user fees are being collected by these Rogi Kalyan Samithis. In some northeastern districts, madam would be in a better position to tell. They are saying that all hospital assets are being given to Rogi Kalyan Samiti and they can garner or generate their own funds, which could be utilized locally for improvement of the hospitals. So ultimately what is happening is the government is not collecting that fee is going to a local institutional body and they are using that fee for development of the infrastructure locally. So legally again the issue comes, who is collecting the fee? Whether it is the government or the local authority. Because initially, I think 5, 7, 10 years back, the government used to collect the fees. Now the government is not collecting, at least in Maharashtra. And as far as diagnostic is concerned, Government of Maharashtra has recently floated a tender, and it's a national policy that all diagnostics and medicines would be provided free of cost to all students. So that's the national health policy. So those two things I think will be taken care of by almost all the states in some time.
So that is what we were talking. In West Bengal, what he was saying is correct. These Rogi Kalyan Samitis are there for the last 10-12 years. And second thing, as the free treatment and free everything is concerned, they have started happening since the last September 2015. So it's free. Free means it's absolutely free, except that 2 rupee charge for the registration.
Yeah, that's not.
So it's only a 2 rupee charge on it. Patients undergoing treatment worth 9 lakhs and 10 lakhs of rupees are also being paid by the government.
Everything, all insurance, all to the
See, innovation is happening at multiple levels. Madhya Pradesh has come up with an innovative model where they are saying that we will not define what is BPL based and all. We will leave it to the discretion of the individual to decide whether he wants to pay the fee or he doesn't want to pay. So BPL and all, when you get those certificates, then some people are excluded because
some difference in the services provided.
no, what they are saying.
Or the
See, in case if you want to register, you charge say a 5 rupee, 10 rupee user fee. So there was a lot of debate at the WHO level whether this user fee is regressive or progressive. How much revenue you are collecting from the government and how many patients you are excluding from the services. That was the debate. So Madhya Pradesh came up with the model that in this user fee thing, they are saying those who want to pay should pay. Those who don't want to, still on that basis also they are garnering a lot of resources. They are able to get a lot of resources through users. That is the point.
See, the point I have raised and that's still unanswered. As we decided that charges paid by the patient should not be criteria whether the hospital comes under the review of Consumer Protection Act or not. If that be so, then all government hospitals, including PHCs, will come under the purview. How can we exclude maybe PHCs and other smaller units where they are providing only the basic services?
No, but I think that can be answered by this another recommendation that before any kind of case against government hospitals are admitted in the consumer court, a departmental inquiry by the particular state or by any other body that is
Not department, somebody independent.
any independent
Most of the cases
like the one that's working in Maharashtra as a pointed out,
most of the
something
cases
like that
when
will come into
suffer,
place.
a police complaint is registered under 304A. Police doesn't arrest the doctor. They will first go for an inquiry by a state board. If there is an element of negligence, then only they will proceed.
Let's keep the
Just follow it in the jack.
let's keep the
That's what they are doing.
criminals apart.
Servicing with such a mechanism.
So,
Exactly. See, we are in a way mixing up 2-3 issues. Agreed that there should be some screening by the expert committee at the admission stage. There is no problem with that. That should happen not only in criminal cases but also in the civil cases. My issue is if charges are not the criteria for inclusion, then even if we accept the screening thing, there will be a lot of cases against, say, PHCs. So the government authorities will be busy with the screening issues, even for small little complaints at the PHC level. So I have a suggestion. Maybe we can, in the act, differentiate primary hospitals from secondary and tertiary care hospitals, so that there can be different levels of services provided.
Yes.
Can that be a solution?
But if
Right now it is not there.
if PSC is not capable of treating viable things, then they will transfer the patient in time. If they don't transfer the patient
Oh,
in
they don't
time,
have an ambulance. They don't have a person to accompany a patient while being referred.
the responsibility of the PSC heads to take care of such
The
logistics.
PHC head may not have the resources. They are taking the responsibility of the government.
Has he ever made a request that he requires such a thing? My question is, if the PHC head knows that he requires to transfer the patient and the ambulance is not working and he has never asked for an ambulance, why he should not be held negligent for services?
You can't have a well-equipped ambulance in a PHC, all PHC.
No, not having ambulance, I am not saying whether it is equipped or not. As what he said, you said that there might be no ambulance. But if you don't have an ambulance, how can you work? And if I have not asked for an ambulance any time, then I am liable.
But still.
So in such cases, basically,
You get one.
I think it was a just a second. I think
The
definition of reasonable care has to be
different.
different.
Actually, whatever criteria, all the internationally, everywhere it is written. The doctor should be knowing when the patient has to be transferred. Now, if anybody is not available, it's not responsible. He will not be held responsible. But he has to know when the patient is to be transferred. Then only we can have different systems.
So we can have criteria of medical care at the primary level, secondary level, tertiary level. And that criteria will be useful also for private setups. Like a small little nursing home in a peripheral hospital cannot be compared with, say, Apollo Hospital. So, in the government setups, if we segregate primary, secondary and tertiary care levels and the services expected from those kind of units, can that be a solution?
Let's take an example.
So the key was the mandate of infrastructure, mandate of manpower is already decided in the IPHS standards. There are IPHS standards.
IPHS.
Indian public standards are there. So,
But can that be mentioned in the act itself? Because the courts are not aware of these standards.
Then the key word is
Consumer Protection Act cannot be amended specifically to.
It can be referred to.
It can be probably a guideline or by judicial precedence there's something in this.
level of care, level of infrastructure is expected at a particular level.
Exactly.
That
So
has
by
been defined.
such things can only take place by way of judicial precedence, I think.
Indian
The
public
courts.
health standard.
You are talking about SOP. Sir, he is talking about SOP.
community health center level. Government has not come out, that NHM has not come out with for the sub-divisional or county hospital or district hospital or teaching hospitals. So that has to be formulated first.
Now, I will give you an example. In a PHC, the patient is often examined by a pharmacist. There is no doctor there. He makes a prescription and something happens to the patient.
सर दिल्ली की पीएससी में तो सीपीए लगता है, ये पता नहीं कौन सी पीएससी की स्टेट लेवल का
PHC में लगता है
सीपीए लगता है सर। बेसिक चीज जो आपने बातों से जो मेरे को निकल के आई वो ये लगता है कि हमें ड्यूटी जो डॉक्टर का पता है, तो रेशो ऑफ डॉक्टर का नहीं पता, नहीं कितने पेशेंट एक डॉक्टर देखना चाहिए, वो भी तो स्पेल आउट होना चाहिए। आप केवल एसओपी लगा देंगे कि ये हमारी ड्यूटीज है, परंतु ड्यूटीज कितने समय में करेंगे आप कि भाई एक डॉक्टर कितने मरीज देखना चाहता है, क्या करना चाहता है। बेसिक कॉज तो केवल यही आ रहा है ना, हमारी क्यों कंज्यूमर के साथ लड़ाई हो रही है, क्योंकि हम उन्हें प्रॉपर टाइम नहीं दे पा रहे, हम उनके साथ कम्युनिकेट नहीं कर पा रहे, हमारी काउंसलिंग प्रॉपर नहीं हो रही है। अदरवाइज कोई लड़ाई नहीं करने आता हॉस्पिटल के अंदर। लड़ाई कब होती है जब एक 400-200 मरीज कैसे देखेगा एक डॉक्टर। अभी डेंगू का सीजन चल रहा है, डॉक्टर साहब जीटीबी के अंदर है, एक डॉक्टर 300 मरीज कैसे आप करेगा। वो प्राइवेट डॉक्टर ने कहा कि आपकी प्लेटलेट्स 15,000 रुपये चाहिए, प्लेटलेट चढ़ेगी, वो आते ही वो तो ही डिमांड है कि मुझे प्लेटलेट चढ़ा, परंतु ऐसा तो कोई सिस्टम नहीं है ना। हमारा भी एक सिस्टम होता है हॉस्पिटल के अंदर, INN हॉस्पिटल 400 बेडेड हॉस्पिटल है, उसके अंदर प्रॉब्लम बेसिकली क्या है कि डॉक्टर पेशेंट रेशो का अभी तक गवर्नमेंट इंडिया साइलेंट है। ये जब नॉर्म्स बने थे 1950 में बनाए थे और आपने सीपीए लगा दिया 1990 या 1980 में लगा दिया, तो मेन फोकस ही हमारा है ना बिल्कुल ही चरमरा गया सिस्टम में। सॉल्यूशन ये है सर, सभी लेवल के ऊपर आपको स्पेल आउट करना चाहिए गवर्नमेंट के साथ, हम लोगों को मतलब कि डॉक्टर पेशेंट रेशो कुछ तो करे सर, ऐसा थोड़ी हो जाएगा।
Talking of solution related to CPA.
CPA ये होगा, CPA के कैसे भी कम हो जाएंगे सर, फिर लगाइए आप CPA।
I think what he feels is if the ratio is not maintained, we are not liable for CPA.
फिर कैसे होगा?
But then how can that be?
How can we do?
I asked this to be our
That problem is sorted out because we have decided that all liability will be vicarious on the government. It will not be on the doctor. It will be vicarious. It is the responsibility of the government to provide a proper ratio. It is the duty of the government to provide proper infrastructure. So the vicarious liability will be on the government for all government hospitals except for the exceptional circumstances.
Yes.
That we have already accepted. Now the question is, if all the government hospitals are coming under the purview of the Consumer Protection Act, because we have decided that charges should not be the criteria, there will be a plethora of cases even against small little things happening at the PHC level. So that is the next question. So for that, if we can have IPHS standards, as he said, can that solve the problem?
Sir, I will just add to your point. Now, PSCs are covered under CP. So there are cases for CP. But when the government has come with this NHM, National Health Mission, there are the sub-centers where the patients are being taken care by the primary health worker, ASHA people. They are not doctors. And they are providing medicines to the patients also. For these things, they are given standard guidelines by the government of India.
It's a government.
But they are
So,
they have
we are
limited number of medicines.
Maybe, sir, maybe limited number. But whenever a patient is coming for a fever, they are taking blood type, they are giving medicines for the fever, like paracetamol or like that. And then they have the option to refer the patient to a place where there is no. But CP is not applicable for those ASHA workers or health workers. So in that case, it can be done. Then the same thing can be done for all government sectors. Government has that provision.
See, it is not applicable to ASHA workers because the court says reasonable degree of care and skill. Because that is the level expected from them. You don't expect the level of doctors from the ASHA workers. But when a pharmacist, I mean, there is a doctor posted in a PHC, he is not coming. And there are n number of PHCs which have this kind of a situation. And the pharmacist, even the pharmacist may not be adequately qualified. And he makes a prescription, he even does the stitching of wounds, and he puts in a rise tube, he puts in a Foley's catheter, and he can create damages, he can create problems. So I think the vicarious liability on the government for all these problems can broadly solve the problem. Exceptional situations where the person has been absolutely reckless or rash, then of course the liability should come on.
But still the time another thing we can do is that if by way of PIL this issue, the court has to take cognizance of this fact that there exists a intermediary gap between private hospitals and government hospitals, and the test of reasonable care has to be different. So this is probably something that by way of judicial precedents can also be checked. Like sir said, that in case there is no request for ambulances, then you can say that there is a deficiency of service on part of the doctor per se or the department head per se. So there is where I think reasonable care on his part has been dispensed when he's put a request. After that it comes, not comes, that is where the government comes into play.
Sir, our suggestion should be very precise, only then they will take it. So according to me, just we can say any hospital which is substantially financed and controlled by state, the CPA should not be applicable for. Substantially means.
How can you say CPA should not be
That
applicable?
substantially.
That means that hospital has the liberty to be deficient in service.
No, 1 minute. They have to go to the civil side, civil court.
I mean, that is applicable for all the.
Because I tell you, the reason. One, when compared to the private doctors, the doctors who are serving for state, they have no right to pick and choose their own patient. Patients are coming like anything. You cannot wait and see. They cannot screen. No appointment, etc. So the question is completely different, number one. Number two, in all private hospitals, where the revenue goes to the hospital management, private. Where these people's revenue goes, state of Madhya Pradesh, state of Tamil Nadu, state of Kerala, state of Uttar Pradesh. So you have to give correct reasons. In Right to Information Act, this is any institution which are substantially financed by government, they are under the ambit of Right to Information Act. The moment it is not substantially financed, it became private. Here also they can put in a, because when you are giving suggestion, minute way, the parliament legislature will hesitate to go there. If you are doing very easily, those hospitals which are substantially financed and controlled by state, they are not coming under the purview of.
What is the rationality here for this? It cannot be equated with RTI because an RTI Act because government said
For example,
to be transparent. That's why this differentiation exists in RTI.
Here also, let them go to the civil court. That's the original.
Put the same thing a little differently. See, I personally feel you can't differentiate legally government hospital from private hospital as far as liabilities are concerned. See, if you put it in a very different manner, that private hospitals are thriving because the government is not running government hospitals win. If the government runs the government
State,
hospitals,
you have to blame.
Whatever you have said, government hospital is not better than the private hospital. The only thing is number of hospitals not coming as per the ratio of the population is going up.
yeah, so that should be,
Workload. And workload is better.
that needs to be addressed.
But we can be
Even the private hospitals, those are unable to manage, they are sending the patient back to the government hospital. I can
See,
work for it.
what I mean.
They will say, they will say
Yes,
yes.
yes.
No,
In
what's
fact,
the
all
point
the
is that
patients
this
are
may not be.
private hospital, all the inpatient.
What's the point is that
All
they.
the terminal patients are referred back to the government hospital.
Correct, sir.
Why?
No, but the point here is that liability of the doctor has to be there somewhere.
I
It's
understand.
the test of reasonable care and what is negligence, I think, has to be
Let's
differentiated.
differentiate between the liability of doctor and liability vis-a-vis the infrastructure.
It's a piece, the doctors in government hospital doing their best even in the unforeseen condition, even the worst condition. In fact, if we have a patient for a ventilator and already a ventilator is full, everything flies back to the hospital. And then ultimately the patient will be transferred without a consent by the private hospital to a government and he cries. He cries for a bed, he cries for a ventilator, everything. Similarly, they have sort of a daily over there. And we are paying maybe around like average 20, 30, 40. If somebody has a duty outside the government, it's become some mother is making if anything happens, the private nothing happens.
And also, in this
It's not
So there's little leeway of the topic at hand. Our topic at hand still remains the kind of liability that is being shared.
See, it's not a tussle between government and private
And
hospitals.
we are agreeing to the
Let
fact
us-
that government
let us-
hospitals are under.
Let us differentiate the responsibility or duty of a doctor and responsibility and duties of the owner of that hospital, that is the government, providing the infrastructure and the support system.
You have to have a grey line there. If it is above the grey line, ultimately you have to have some buffer. Or maybe
See,
some,
maybe we can have some rating system.
yeah.
All hospitals can be rated, 5-star hospital, 4-star, 3-star. There can be some accreditation criteria for that. And so that there are different standards of care for different levels of hospitals. Maybe we can have that kind of a system.
no, sir, I have to raise
But
it.
that means that
In
the
regards
private
to-
government are also.
All. I mean, in private also you have different levels of the small little nursing homes in peripheral area. They are struggling with funds. I mean, you can't compare. You can't say that all private hospitals are like a Apollo hospital. So I think the debate should not be between private and government. It should be broad, where the private and government all are covered. So it's a question of the management of private hospitals and the government which is funding the government hospital. And in a way, government has a lot of funds, taxpayers' money. They have a lot of funds. There's no shortage of funds there. But it's the application of those funds. It is the management of those funds, management of resources, and not anticipating the problems. As you rightly said, the proportion between the ratio between patient and the doctors, that needs to be addressed. You need to have more hospitals. You need to have a rational approach of referral system. Every Tom, Dick and Harry comes to the AIMS. So they have all the, so there has to be some mechanism where these issues are addressed by the government, the employer. So
NABH be a solution to it.
yeah, NABH or any other accreditation authority which can rate the hospitals maybe.
Government is already working on this.
But the problem is that we know that Consumer Protection Act has increased the cost of treatment, especially for general public. Because of the act itself, people are investigating more. Somewhere down the line, the cost of
Insurance also, they are looking at the insurance.
So doctors, because there is cost involved as far as means doctors are insured themselves. Somewhere the cost is passed on to the patient. So medical treatment after this Consumer Protection Act came in practice has increased. Doctors are taking for means the trust level between the doctor and patient has come down, and more investigations are done, especially in the private sector. In the similar aspect, what I want to say is, in case if we insist more on this public-private public hospitals, it should not happen that in the process, a lot of doctors struggle with the responsibility of treating the patient because of the fear of the act itself. I hope I am able to convey my
See,
view.
you can say that many doctors are diverting to different wings of medical practice. maybe teaching, and they are not inclined to send their children to this profession, that can be there. These are the
No, I'm talking about the treating doctors.
the treating doctors
So
is not refused.
as far as the teaching of doctors is concerned, teaching includes practice as well.
No, sir, I think
So
probably
it's not so that a person, a doctor who teaches is not seeing patients.
No, sir,
They are
point
looking
I
after the
think.
patient, but whenever they are seeing the
It's a
patient,
dual responsibility.
Right, but
It's
sir's
not
point is
same
that just because Consumer Protection Act is another liability or another headache for a doctor, that is why doctors are shrugging away from probably
Yeah, they are
joining,
joining.
yes, from
They are
I
joining.
have two more points. What we have seen, there has been a lot of debate that this act itself, where it has improved some accountability of the medical
That's
profession
always-
towards their patients,
always there.
but it has come with a cost, and that cost has to be borne especially by somebody, by the vulnerable section of the society. Cost of treatment has increased significantly and substantially.
Cost of
Treatment.
But it can also be taken another way, sir, that quality of doctors and how their responsibility is
Exactly,
also.
that is the point. I started with that. There is a trade-off here. What I am saying is there is a trade-off because patient means you want accountability and responsibility of the medical profession. You want to protect patients' right. This is one side of the thing, and the second side is that there is a cost involved. Ultimately, who suffers? I mean, the most sufferer in this whole debate is the vulnerable section of the society. Over a period of time, cases of medical impoverishment, and there have been quite a bit of empirical research on that has increased because of this. But that doesn't mean we should not progress. Only thing is that how should be the transition?
You have to balance it.
You have to balance that.
See, I'll take you to another area which might be connected to this. As we said, there will be plethora of cases under the CPA or vis-a-vis the government hospitals. And for a minute, we don't talk about government or private. If we want to reduce the level of number of CPA cases, maybe the penalty clause for the frivolous cases, that is ridiculous in the present act. It is up to 10,000 rupees. If we can have a rational penalty for frivolous cases linked to the amount of compensation claimed by the patient, say he has claimed 50 lakhs or 1 crore. If we say that if it turns out to be a frivolous case, he will pay a penalty, say 50% of the amount he has claimed. Something of this type. This will discourage patients from filing frivolous cases. So can that be a good solution?
And this will be for everybody, not only government.
10%,
5%.
not an issue, maybe 5%, 10%.
It should be if they are cost it so sometimes even if they are already
If
cost.
50%, he will announce the figure. He will say 100 crore.
Saying that if it's a claim of 10 crores and it turns out that this patient, it's a frivolous case that he has initiated, just say to harass the doctor or to settle some personal score, then the court will ask him to say, submit costs. 50% of 10 crores that you have claimed, you will submit to the government as a penalty clause. So this will be as a deterrence in the public to file frivolous cases.
But government, court has penalized the doctor in crores. There are 2-3 cases in India.
See, we are addressing the same issue. There is no cap on the amount you claim as a compensation. The complainant can complain anything.
It's subjective.
So to contain that, if there is a clause that frivolous complaints will be liable to pay a penalty, say for example 50% of the cost that you have claimed, so there will be an automatic cap on it. Number two, if it's a frivolous case and the patient is also reasonably sure that he is filing a frivolous case, he may be just deterred in filing the case. So number of cases will come down and the unreasonable cost claimed will also be contained.
The deterrent has to be there. It's a good suggestion. Only thing is that cap, it should be 10 to 15% according to.
Some 20% that acts as a deterrent.
We settle by 20%.
Are you drawing the point that is in that 2011 CPA draft bill in the pending in front of Lok Sabha that is already in place to the Lok Sabha that there is a required excessive security deposit. There is a security deposit to give for a party. there was some amount of security deposit for claim, percentage of claim. Are we talking that point? Or are you taking
The
this?
security deposit will be difficult to implement. A
Why?
poor man,
That's already there.
It is already in the
That's
It's a
a
suggestion,
It's a
it's a
suggestion.
suggestion.
It may not be taken.
No,
That's-
it's a draft bill.
Exactly, sir. It may be dropped.
It will be dropped.
It may be dropped.
Because a poor
It is
man,
not
the
a-
consumer courts are meant for poor men. So a poor man, if he goes to a court and thinks he needs compensation of 50 lakhs,
This would be
how will he deposit the
more than
security?
extra deterrence. People who have a valid case also will not come up. They who
I think
somebody
the
who's
two
lost his
most
life,
important
somebody will
deterrents,
come.
two most important deterrences will be one, screening of the complaint by the expert committee at the admission stage, and second will be tagging the frivolous complaint penalty to the amount claimed. And thirdly, there is an issue about the frivolous complaint. What is a frivolous complaint? That also should have an objective criteria, because till now it is the subjective opinion of the court. There should be clear objective criteria as to what amounts to a frivolous complaint. And if it satisfies that criteria, the amount of penalty should be fixed in the act itself, that it should be 20% of the compensation claim.
The patient can never actually leads to a certain whether it is frivolous or not. This is a relationship step. The patient will never know how he can say that whatever complaint I am filing later on will be turned into frivolous.
There should be objective criteria. That is why I am saying there should be clear objective criteria which should be publicized. So everybody knows that if you are filing a complaint which is within this criteria, better not file it.
You should know what services are being provided by the place. And it is saying that this should have been provided and it is not getting it.
The court,
You can go for
it
it.
should not be the discretion of the court. I am saying it should not be the discretion of the court. It should be part of the rules of the
procedure.
procedures. It should be within the law itself. It should be a written law that these are the frivolous, the criteria which will amount to
So,
frivolous.
but are we saying that apart from the Consumer Protection Act, there has to be another rules and guidelines that needs to come into place for medical legal cases in the Consumer Court?
In the act itself, it can say that in the penalty clause, they should define what is frivolous act. In the definition column itself, they can give the
But
definition.
that has to be, that will be an objective thing for all kind of cases and not just medical legal cases. Because Consumer Protection Act
Fair
will have.
enough, fair enough. I mean, we can have, there are frivolous cases in other walks of life also.
Right, correct. But is it possible to keep all of them together and come out with a criteria? Because I'm sure
Or we have
medical-
something special for medical legal cases, what
Right.
she says.
Yeah,
Because
so-
otherwise it will be a sweeping thing in case if this a particular product and an electronic goods for that matter. So you are mixing.
So if we ask for something special for medical negligence cases, we have to justify it.
Because it's altogether a different commodity. Healthcare service.
Involves
It won't be that difficult. You need to justify.
Involves human life.
It involves human
So
life.
that's
It
what-
requires expertise.
That's why I say, that's why my suggestion is that probably a kind of a PIL or something that a court or suo motu cognizance needs to be taken by the court, and the precedent needs to be set that such cases in case of medical negligence would amount to a frivolous
See, the courts
case.
already have all those powers. We are discussing about the enactment. And courts, they have immense powers to lay down guidelines and all those things. But we want to have things written in the act itself. So I agree that there can be two sets of criteria of frivolous cases. One for specialized services like medical service and the other for routine services.
Sir, another one. In road accident cases, NCOP cases, clinical trial cases, ESI, Workman's Compensation Act, the law, the act specifies the procedure to arrive at the compensation amount. Here in Consumer Protection Act, there is no cap. Many awards are being given subjectively, not objectively. Every judge is giving in so way, there is no maximum cap. In all these compensation cases, Workman's Compensation, ESI, clinical trial, all these things, there is a specific procedure to go. Motor accident, you know that, how much compensation, liability of the family, age of the person, earning capacity, loss of revenue, all these are taken into consideration and they arrive at a definite quantum of money. But surprisingly, the Consumer Protection Act, it is completely subjective.
Legally, in
1 minute, sir, 1 minute, sir. I am today I am giving a 20 lakhs for this man. Another day I am giving another value lakhs. And with due respect, I tell you, in Gunar Saga case, they given 6 crores, with interest it comes 13 crores. I still doubt with due respect the reasonableness. Yeah, all women, thousands of women are dying in India. Thousands of women are dying, we are not giving any money. If at all we are giving 5 lakhs, 3 lakhs, even small lakhs only. Poor people don't get it. Women are dying every day. But this Gunar Saga's wife is so special. Our blue respectable Supreme Court has given 13 crores. So, I tell you, in the accident case, the loss of revenue, one criteria, loss of revenue. 2, medical bills completely reimbursed. Loss of revenue, medical bills fully reimbursed. 3, permanent disability or temporary disability. This criteria, number 1. Number 2, family liability. I am having 10 children. I will get more. He is a bachelor. He will get less. I am having 3 wives. I will get more. See, and longevity. My forefathers lived up to 90 years. I will get all these small considerations are taken into consideration for 3rd criteria. First one, second are definite. No subjective distance. 3rd is the indefinite, taking into consideration of all these areas. Suppose I am an engineer, software engineer, I get more. I am a manual man or housewife, less. So here the procedures are definitely given that and rules framed. But unfortunately, most unfortunately in CPA, lavish way of subjective distance. Today he is a very good mood, he will give 30 lakhs. The same judge tomorrow.
That leads to individual discretion.
Suppose that is a
I don't really agree on this point because a lot of cases, I'm not talking about only medical legal cases, however, under Consumer Protection Act, such things are taken care of by the judges. I'm sure there are some cases where we are lacking.
No, but no, I am telling this, with due respect I am telling you, better we will represent it. We will represent it. We cost nothing at all. Put a cap for this, so that at least first 2 criteria are different. 3rd can be putting a seal 3 times, not exceeding 5 times, like that you can put a criteria, so that judges will act within the 4 walls of law.
See, you can't put a seal, one. And when we talk of putting a cap in medical negligence cases, then they just say why doctors are so special.
Sir, similar laws are there. Evidence compensation is there. ESA is there.
We can
laws are there.
get that solution in a different way. See, when I talk of
maximum 5 years, maximum 7 years. So similar.
That is a valid point as far as doctors are concerned. But the lawmakers may not understand that. So we can have the same thing in a different way.
The suggestion can be that while calculating the compensation, like you said, what is the earning capacity of the member who is in jeopardy?
There has to be objective criteria.
That is already there. But because it is a quasi-judicial forum, they take shelter under that and give a lump sum kind of a compensation. So we can make it a point that it should be strictly within the guidelines framed by the Supreme Court in this condition or by the MACT Act. It should be comparable strictly, it should be calculated strictly based on the MACT Act.
Sir, we will represent it, let them decide why we are blocking stuff. We will represent it. See, we are not violating. Represent that there must be a procedure clearly specified.
That is not sealing.
MACT Act, they in fact they are supposed to adopt that procedure for calculating compensation. But because it is a quasi-judicial forum, they give a shortcut and say lump sum. I think it will be good enough if 1 crore is paid. So if we add the frivolous complaints to the amount of compensation claims, that will contain the compensation. And if we insist that there should be strict implementation of MACT criteria while calculating the compensation, that will also contain this.
Sir, with due respect, please be positive to receive my suggestion. In one case, in the Supreme Court, for failure of ROP, there is a small infant in Tamil Nadu, government hospital, ROP. They failed to do the ROP for a small infant, newborn. They have given 1 crore 50 lakhs. Who has given? Not quasi-judicial, Supreme Court. And the state of Tamil Nadu is asked to pay. for an infant. So, normally in NCOP all other cases.
Supreme Court must have gone in appeal.
Yes, sir.
So at the lower level, they must have.
Anyway, I make it point that
So, but also,
there
I
must be
think
some reasonableness there.
this also, don't you think can be worked other way? That this is something good that the court is also taking care of, because then the government and doctors will also be more careful.
Sir, for
If there's higher
say when you are
competition.
conducting the case,
But then
seems
it
okay.
has to be uniform.
For an infant,
It can't be good for
you should not order control. That's taxpayers' money. Taxpayers' money.
अभी कल ही जजमेंट आया है इंदौर से
Uniform-
उन्होंने 43 लाख रुपए दिए इसी आरोपी के ऊपर।
I don't know हिंदी।
इंदौर के अंदर एक केस हुए थे 25 साल पहले, उसका कल जजमेंट आया, उसमें 43 लाख उन्होंने अवार्ड हाई कोर्ट।
So yes, we should be realistic, you know.
See, now 1.5 crore and 43 lakhs.
Are you giving some
Objectivity.
Objectivity is awarding.
See,
So let us,
MSCT
bottom line is
management
objectivity as well.
Please, we should follow that.
Yeah.
And they are in fact supposed to follow that, but they usually don't. So if the act it says that strictly it should be as per the MSCT regulations. So that will serve our purpose.
So there is one point, let us all, probably everyone of us knows that why Consumer Protection Act came and why, in how many days they are supposed to give judgment. I think in 3 months.
3 months.
But there are lots of cases which are pending. Can we recommend that for a population of 10,000 or 1 lakh or whatsoever figure we decide, there should be so many courts? What is happening is the number of cases are going on increasing in court. The doctors and their families are shattered mentally, emotionally. What many of us have said that the cost is going to be going crores. As she said, this will make the doctors more aware and more responsible. On the other hand, the doctors are becoming more defensive. Therefore, the costs are increasing, which the burden lies on the patient. If the number of courts increase, disposal of cases is faster. It is much easier for both the sides. So I
This
think
is a problem we are facing.
Go ahead,
This is a problem we are facing.
It is easier said than done.
It's easier
We
said than done.
can have it slightly differently.
No, but it's
See,
easier
it's
said and done
tendency-
for the judiciary. So it's the same thing for said and done for the medical people.
Of course, of course.
That's why
yeah.
we're coming
See, we are talking of increasing the number of courts, it's talking of, and it's easier said and done is the answer. What about the hospitals? It's
Many
easier
firms
said
don't
and
have
done.
any precedent.
How to increase the
Many
number of
firms.
hospitals and the number of doctors immediately. So if
That's why I said we are talking
So
about.
that's why as far as the
That is
manpower
why
is
exactly
concerned,
we're deliberating
See,
this
as
topic
far as-
about the government hospitals and their responsibility today, because we realize that increasing number of government hospitals and doctors is something that cannot be done within a span of a
it's
year or
another
so.
thing. So it's the same
We
everywhere,
have been
it's in
saying
every
this for
service.
last 20 years.
That's why I'm saying it's the same for the last
If we can just come back to the.
I will now divert it to something different,
Yeah.
also related to this. That the high pendency of cases has a number of factors. One of the factors is too many adjournments. Another factor is too much of involvement of lawyers in these cases. Third is lengthy judgments, and many a times they are very ambiguous judgments, and it gets boiled down to appeals and revisions. So maybe if we can say that after the screening stage, the case is admitted, then the preliminary attempt should be made without the lawyers. One attempt without the lawyers, and some जैसे बोलते हैं पंचायती फैसला करते हैं, the court sits in and they have both the parties there.
Lok adalats.
Sorry?
Lok adalats.
Something like some preliminary attempts to resolve the issue.
Because both the doctor and patient gets fed up of all these things.
Yeah,
and spending money to the lawyers.
Alternate system of adjudication. Some preliminary stage where they can sit together and the court can just be a supervisor and mediation kind of thing. And then I think 20-30% cases will be sorted out less. And then if the courts are told that these are quasi-judicial courts, you don't have to give a very lengthy judgment. We should limit it to say 3 pages, 4 pages. And similarly, the pleadings should be shortened. The complaint along with the affidavit should be submitted at one go. The reply and the affidavit should be submitted again, and no rejoinders. And come back to the arguments.
So, but then again, if you see, is this
Sir, I am against mediation.
entirely,
I am totally against mediation or reconciliation.
but is this
Because that
entirely
will increase
practical?
the number
Because
of
the
cases.
sensitivity of the case, the kind of investigation that has to go into a medical legal case is much higher. Hence, the judges also have to give a very reasoned order. So, limiting the number of
If you
pages
think
of the
that
judgments
the-
is something that I think
See,
is
judicial
not
order
practical.
case- if you think
Judicial
that the
order
case is
must have
complicated,
reasonableness. They have to give reason.
if you think that the case is complicated, refer it to civil.
Which
I
is
mean-
done, correct.
I mean, we
Which
should
is done.
take the help of civil courts in complicated
But they
cases.
have to pay the stamp duty for the consumer.
Fair enough. So, that should be deterrent. That should be deterrent.
So, sir, 10% comes. 10% of the claim amount.
Actually, consumer courts were formed only for simpler cases.
This is
They were not meant for- they were not meant for
How they
complicated
pay
cases.
10%.
So if we, why you are against mediation?
No, I'm just saying mediation is basically a compromise form, reconciliation between the two parties. Here, basically what the patient is challenging, what is the challenge between the patient and the doctor, whether negligence has been committed or not. So it is a binary function, yes or no.
No. See, many a time it's not negligence, it's just deficiency of service. The person did not talk to me well, the sheet was bad, and he did not wash his hands before touching me. These kind of trivial issues. So I personally feel 20-30% are such issues which can be resolved if both the parties are allowed to sit together. They don't sit together.
Sure.
They don't even come for a grievance redressal to the hospital.
Like an independent
So just like a
ombudsman.
diverse case, they have a
Or
counsel.
maybe it could be made mandatory for the hospitals to have a grievance redressal mechanism.
Yes, that's a good suggestion. That's a good
Sir,
suggestion.
in a diverse case, we are getting counseling to compulsory
Counseling or grievance redressal mechanism, some institutional
Yeah, some.
platform which
At
takes
least
care of
in the
these
tertiary
issues.
care hospitals, at least in the higher category of hospitals, we should have a grievance redressal mechanism, and we should have criteria that one or two persons from outside should also be parts of the council, and it should be mandatory for the complainant to first approach that grievance redressal mechanism before coming to the court.
labor matter
So
conciliation.
we may sum up the first 2 points that we've been discussing about. A is removing government hospitals under Consumer Protection Act and redefining vicarious liability only in cases of government hospitals. Like, I think we've gone a little beyond our agenda and we've gone broadly into judiciary, how it's been functioning. If I may please sum up what we've been talking about.
Just one point before you sum up. As you said that we should have some institutional mechanism at the government level to reduce the number of cases. That can be done across things. Means before going to the moving towards to the consumer court. In case if we have some grievance redressal mechanism or institutional mechanism which will look into all these aspects and within a time period of say 6 weeks or 3 months, then the applicant can go to the
It's
consumer.
already there.
It is, but it is not functional. It is there. It is there on papers. But because it is not functional.
Legally, subsidiaries are supposed to do this.
But sir, this is not. I
But there is no
belonging to
bar.
a government hospital. But it is not functional. Once we make it on paper, the number of cases going to consumer courts will come down substantially.
So, but there is no
I
bar
can
under
vouch for the
the
central
Consumer
government
Protection Act,
hospitals.
right?
In central government hospitals, we have such committees. Grievance redressal committees are there.
Yeah, up one year.
And
Up 1 year.
even at the village level also,
Yeah, yeah.
finance committees are there. They are supposed to look into it. If they are not doing it, they are not doing their
No,
job.
now you come.
Okay, what I would like to suggest is, if the patient, if the complainant wants to go to the consumer court, he must first mandatorily
Yes.
approach
There
this
has to be a
committee.
statutory bar under the Consumer Protection Act to go to
After,
the independent
after.
authorities first before approaching the court.
Yeah.
Yes, yes.
That has to be a statutory requirement.
That is as good as statutory requirement. And second thing is in regards to what we have suggested is that there should be a medical expert team who will screen out these cases. I think then the patient or the complainant should have some mechanism within the system where he can go in and appeal also. Because in case if the team rejects a particular application, inherently there should be a mechanism or an institutional structure where in case if the patient is not happy, either he can go to the court or he can have some mechanism.
Maybe it can be medical counsel.
Yeah, anything.
Or else these medical inquiries before admitting the case, the consumer
Yes,
court,
yes,
it will not be binding on the consumer court. It will be a recommendatory form. So if the consumer court accepts this medical inquiries report, then this person will directly go under appeal to civil court after.
In other
It will
cases,
be recommended.
already there is a medical
So,
code.
for every new member, we will just.
Ask what is the purpose of this so-called local level committee? Now, what we are talking is that it will be, a step before the consumer forum. But do they have the power to reject or accept? Or it's, sort of imply to remove the misapplication, misperception?
Exactly. Because many of these cases are because of this lack of communication.
Correct.
So we need to put them together.
And then, even after that, if the consumer is not satisfied, he has all the right to go to consumer court. It can't be in the form of a rejection or acceptance. So this is not
Rejection acceptance was related to the medical expert committee. See, there are two things. One is the mediation before approaching the consumer court. And second is once the patient and complainant has gone to the consumer court, the consumer court at the admission stage will refer the matter to an expert committee. And if the expert committee says there is prima facie some degree of negligence, then the case goes on. If it says prima facie there is nothing negligent in this, then the case cannot go on.
Recommended. No, let's not do it. They cannot go on.
It is not a judicial body.
Not recommended.
Just
Like in Mumbai. I want the
conciliation.
Please remember,
Conciliation fails only if you raise an idea.
it's for criminal cases because the standards for criminal cases are much different, very high. This cannot be applicable for civil cases.
That is in Jacob Matthews, it was exclusively for criminal cases. In Martin D'Souza, he said even for consumer court cases, it should be the screening to an expert committee. That was the Martin D'Souza.
Now,
it has been overruled, of course, but we want to put it in the enactment that in medical negligence cases, it should go through a screening committee of an expert committee.
again, who will comprise of this expert committee? Because I will tell you the reason why I am saying this. In Bombay, every case has to go to jail, and there is a in other districts it goes to the civil service. Now the level of expertise with civil surgeon and its team, whether they will be in position to opine or not, is itself a question. And there is a lot of corruption in whatever is going on. So when you say a committee, then you have to have some mechanism what committee do it, and the treating hospital should not have any member from his entire fraternity as a member of that team because it can be biased. So you have to have those details also.
They will not be able to do anything. We are trying to improve the system a little bit.
Correct. But there will be unreasonable recommendation because nobody will accept it. You send the recommendation like it's my hospital, and my hospital committee expert will decide whether it is acceptable, whether there is negligence. That can be done.
See,
Sir, I think what we can do is
there can be objections from the other side. They can be referred to some other district. I mean, those things are happening.
Such things will only create more procedures, more hurdles in dispensation of the case. So what we can do is like, I think somebody from here would suggested that in state of Maharashtra there exists a government body that sees into the cases that are coming against government hospitals. There's some kind of screening that exists in the state of Maharashtra.
Correct, but not.
No, it is otherwise. The court decides the case, then the government pays a compensation in case it is cash compensation. Then government sits over the case, the judgment of the court. Then government initiates inquiry against the person concerned. In case it is directly responsible, then government would initiate action, would
Administrative action.
administrative action. Otherwise, the government pays the compensation.
For the patient, you have to pay the money.
Yes.
You can make administrative.
Wherein they can sit together, they can decide. And if 30% of the cases might be resolved at that level. But if the consumer is still not satisfied, he has all the right to go to the Supreme.
He has all the right, but I think we should suggest that screening by the expert committee, whether the lawmakers accept it or not. I think it's a very valid suggestion, and in that 2-3 years period of Martin D'Souza era, there was a lot of screening of these cases. Many of the frivolous cases are just screened out.
So, but also if I may suggest, from from a legal perspective, at the end of the day, Consumer Protection Act remains a general act. It is not a special act that can be amended only in terms of medical cases. So either this has to be decided by a way of a judicial precedent, or there has to be certain special law or guideline that needs to come into place along with Consumer Protection Act. Because if such an amendment is done only in medical legal cases, various other issues will also come up. At the end of the day, a COPA is a general act.
It's a general
any
act,
kind of services.
But our experience over the years has taught us some certain things. So in view of that education, we would like to have some implementation technical issues. Because actually the CPM is not meant for technical matters. So since we have decided to improve technical matters, so we should have specific guidelines also.
Again, even architects are covered under it. Even builders are covered under it. But for this very reason, they have at least at state and national level, I know that one medical doctor who is a member of the.
It's not essential.
It's not essential.
Not essential.
It's not essential.
That you can say that there should be a necessarily a member. That would be a.
No, that's what like
Ready-
Sharda case, it talks about this, and that says that the moment there is an expert opinion that is required in such cases, those cases should be relegated to a civil court and not a consumer court, because consumer court is a quasi-judicial forum, not equipped enough to go into these intricacies of evidence. Like negligence cases, you need to go through evidence,
We already decided
examination.
that all complex cases have to be referred to civil.
So if I can please sum up so that we can.
Something happened at district court, then regional body. If something happened to regional body, state body. So they are already
In place. Just one other point. What happens is whenever a patient complains of any kind of negligence or misbehavior, they puts in a complaint, all cases together. I mean, puts in a complaint to the local authority, law city, gives a complaint to the consumer protection forum, puts in a complaint to the Thana, and puts in a complaint to the
That can go side by side.
That can go side by side.
Rights are prepared. That एक दिन and they give applications everywhere and come back and say हमने ये कर दिया, now do whatever you want to do.
That is the easiest thing.
So if we are talking about
time, if I may please sum up the first two subtopics so that we can move on to the next two subtopics also. If we're all in agreement, the first recommendation out of the session is that there should be no differentiation for government hospitals and private hospitals when it comes to the fee part. Rendering of services should be irrespective of whether there has been any money that has been charged. If everybody is in agreement with that. Correct? Second thing is there has to be a penalty clause for everybody. So that it acts as a deterrence for all kind of frivolous cases that there are. Penalty clause to the effect that say 10% or 20% of the amount that is claimed. In case there is a frivolous case, the court will ask the complainant or the claimant to submit the costs to either the government or the court. Then also
stop the people from accessing districts. And if I will put a similar analogy regarding the user charges which is there in the health, that we know this very basic principle that even 2 rupees or 10 rupees token money, that is irrelevant. You are
but then how do we,
No, I don't agree. I don't agree to this. In health, it is regression. I agree to that point of view. But somebody approaching court of law asking for compensation, and he has to go with clean hands. He should be very clear that his case is strong enough.
But how you get to know this?
No, sir, frivolous cases, sir, as a matter of natural justice, complainant has to come to court with clean hands. When you see that, when the court feels that objectively this case has been instituted with the intention to say extract money or harass the doctor or hospital, that is when such stringent ideas have to come into place. And this is something which
And
happens in
maybe our
case
judiciary is mature enough to understand in case if the patient was misled by some reason or he has come, the court will not charge him. But at times the evidence is manipulated. At times the doctors are unreasonably being harassed. Just to have a deterrent effect, this clause has to be there.
Moreover, when we have decided that there has to be some grievance redressal mechanism before the complaint goes to the court, at that level he can be apprised of the liabilities if he tries to file a frivolous case. So that he can be educated about.
The deficiency of air and the compensation arising out of it, that cannot be taken care by the human citizens.
That cannot be taken care of. But the trivial cases or the cases where the patient has just some ego problem or some such things, they can be taken care of.
They can be filtered. In case the
We just
patient
want to-
is not happy with the decision of the
He
government
always
interest,
has a right.
he can always go to the consumer court or the civil court as he deems
It
fit.
should be mandatory to approach the previous mechanism. He may or may not accept their verdict. He can still go to the consumer.
Sir, it will be useless one because if even the court says, consumer court says, this is a frivolous case and find something, if the party doesn't pay, then we have to, the person has to go to the civil court to get that.
Correct, sir, correct. Anyhow, when there is a cost that is imposed, the person will have to go to an executing court, the government or the.
Then it's useless.
No, he has legislative powers.
Has magistrate powers.
Execution court has legislative power. You can.
A consumer court decree is an order of a proper court's decree. It is implementable in case the executing court feels that the complainant is not acting upon it, there can be a contempt action taken against. A consumer court decision is in no way less deterrent than a normal court's decision.
Maybe we move to
That
the
option
second.
is there, that it can find itself. It is the doctor the complaint was made. Now the consumer court says this is a criminal case. Now the complainant should have to give the fine.
That is in place.
That's what they are saying. That is what they are saying.
That is in place. That is in place already. That's what they
The
are saying.
second issue listed here, we have already, I think, deliberated on. Redefining the vicarious liability of doctors, teachers in government hospitals and medical colleges. By and large, we have discussed that there should be vicariously liable, the government should be vicariously liable,
Also, if
except in extraordinary situations where the doctor or the employee is outright negligent or reckless.
And in legal terms, as I said, that the test of reasonable care when it comes to a government hospital, a government doctor, the courts have to interpret it in a more practical manner. The courts have to take cognizance of the fact that government doctors are working in an entirely different setup, under the resources are not as much as they get in private hospitals, and nor are the infrastructure enough. So this is something that has to probably come into place case by way of judicial precedents existing.
As far as second point is concerned, you have not added that institutional mechanism, grievance redressal mechanism. Before the, it is there with you. She is writing out the points.
No,
So it should come as.
Combine the points. The third issue is, sorry? See, the consumer court and the court judgments, they have already said that the average person under the given circumstances, how he should behave, whether he has behaved in that manner or not. So that highlighted that the circumstances of the hospital, the nature of the hospital, the facilities available, the infrastructure, that should be taken into account to see whether the person has acted like an average person has also.
So if the concern was that about this vicarious liability is that I am insurance department, another unit head who is professor, and there is one junior resident who has behaved recklessly, and he was not supposed to. He was not acting as per my directives. Still, I am responsible.
So that's what our entire
It is the
concern is.
employer who is responsible.
Employer who is responsible.
Not the head of department, not the government.
But how
So
did
the
that
best-
comment?
Everyone is.
Head of the department.
So
They
that's
are
what the recommendation is.
supposed to train the staff, they are supposed to educate them.
I will give you an example. I am supposed to train like the absolutely fine. What if senior resident comes under the and does something good? I am not trained into that. I am supposed to ensure that he goes under.
So in such cases, the personal liability is of the doctor who is committing this. Exactly when I said reasonable
See,
care.
if it is a criminal act, it's under the influence of alcohol, he has injured somebody.
He is not getting and what if criminal
shows the definition of reasonable care has to be differentiated. So, like you said, in these such cases, it has to be seen that as a senior doctor, has he given him the right instructions? In case yes, he's given him the right instructions, then the liability will not be of the senior doctor anymore. The liability of a person. Yes, sir. This is one of the. It's not.
Cannot be as one. Say if the senior head of the department gives one list of instructions and keeps that as an evidence that I had given the instructions, that is not enough. You have to train the fellows, you have to keep an eye on them, you have to supervise them, you have to take feedback. There are so many things to be done.
Correct, so many. I agree. But you just it's the practical situation. You have, say, in surgery there are 36 residents. Now it is possible that the head of the department को 4 लोगों का नाम ही नहीं जानता होगा because he has unit head who are professor and head. Sorry, professors. उसके अंडर में कर रहा है, उसने कुछ किया तो आपने एचओडी को बता दिया, आपने टीम को बता दिया, साथ आपका एम्प्लॉयर, and now if you see going to the principle why employer was responsible before it becomes a responsibility to appoint a properly trained person, is that right? Now here resident is undertaken, and junior resident is appointed not because he wanted X person to be appointed. It is as per the national eligibility test. He is working here. Understood?
Yeah.
Now in चक्कर में कुछ गड़बड़ किया है काम करते हुए. So therefore in
Getting at that point, he needs to be supervised. If he is under training, he
Sir, not in the dead of the night. Stop saying I'm the head of the party.
If I may please sum up, when it comes to a case, such evidences are led. If in case it is shown that there has been some lack on part of the dean head or some lack on the part of head of department, it is only then that these people should be held liable. Like sir said, in government hospitals, when there are requirement of ambulances, he is put in a recommendation that we need more ambulances, and then the ambulance does not reach on time. That is when he will be absolved of his liability. But if we've seen that he's been making no efforts to get more ambulances, or any kind of supervision is not existing on his part or his junior doctors, it is only then that such kind of liability should be attributed to these senior doctors. This is something correct.
Some recommendation because what happens in private sector. See why we are saying for government. In private sector, in corporate hospital, your management is responsible to whom you are hiring. As a dean, I don't have control to whom I am appointing as resident.
The government is the employer. Government is vicariously liable.
Sir,
इसमें हम एक चीज ऐड कर सकते हैं, मेडिकल इंश्योरेंस डॉक्टर्स का, गवर्नमेंट डॉक्टर का मेडिकल इंश्योरेंस करवा.
सर ये जो बोल रहे हैं सर, ये एकदम फैक्ट की बात कर रहे हैं, जहाँ पर सभी की बात कर रहे हैं. रात में 12 बजे हमारा रेसिडेंट जो है वो सर्जरी करते हुए जो हमने उसको सिखाया है, इंस्ट्रक्शंस दिए हैं, पढ़ाया है, समझाया है, वो कोई नहीं करता. 36 में से कोई 36वां लड़का उसकी भी कैरेक्टर रिस्पांसिबिलिटी है.
That calls for departmental action.
Department might not be there. Even rules of residency are such that the nature of emergency duty
No, but when the case is filed, the case will be filed with the HOD.
How will the dean may
There are cases in all the studies.
So what we can do is we can if I may, the issue is that monitoring in government hospitals, should the senior doctors who are not in the operation theatre while the resident is, say for example, conducting the surgery, should they be held liable?
Directly or indirectly, they are not.
हो ही नहीं सकता मैडम, इंडिपेंडेंट कैसे करेंगे सर्जरी.
Government is is money. Just wait a minute. And it is the duty of the government to have adequate number of people, to have a proper checks and balances. As far as the HOD or the senior resident or the consultant or the dean is concerned, they can have a departmental action, departmental inquiry to see whether there was some lapse at their level or not. If there is no lapse at that level, no action taken. If there is a lapse at that level, some action needs to be taken. But that will be only
Sir,
departmental.
also, when such cases come to consumer court, the doctor or the government hospital has to bring this in light of the court that this is what my duty was, this is how I dispensed this. Apart from this, what happened was not under my control. Such evidence has to be led before the court for the court to take cognizance of such things. It is only when you present your side of the story before the court will the court take it.
That aspect we have already discussed and said that
you are right. He will have present himself that why I was not head of the department officer, whereas it was the mistake of the unit head who was associate officer or some resident working under the वो पेशेंट नहीं देख रहा है एक केस आ गया दूसरा इतना समय जा रहा है when you say government who is government gets money that's fine but in this case who becomes government
becomes government. Your legal representative, he will waste his time, not the dean.
no sir I have to give an affidavit I have to appraise him I am staying there all the guys will be sent to the lawyer
That will happen, sir.
That will happen.
That is,
therefore there has to be some measure what we have decided that we can't have a mechanism wherein government hospitals are not under the purview of the protection act that is not possible
so that's what one of the recommendations was, that the test of reasonable care has to be interpreted differently when it comes to government hospitals.
when I am not judging
What is reasonable care?
when I am not judging anything does the patient becomes consumer
Sir, under the current law, it is not a consumer.
correct
But that's what one of the recommendation was, that this kind of a barrier should be taken off. That whether or not you're charging something or not should not be the consideration. Whenever you're rendering a service,
The complainant is paying his
should be a
taxes.
consumer.
The complainant is paying for his services indirectly.
that's what
That's what the panel recommended.
There is a well, in one case, Supreme Court has given a verdict regarding this consumer case. The patient for delivery was given spinal anesthesia. Consumer Court has fined the doctor. But Supreme Court said this is not proper because you have to judge between the pros and cons. There are risks, there are benefits. So judging this, Supreme Court waived of this. So that should be in our recommendation also. Suppose now NHM cases, Jodhana cases, JSY, every maternal death and every infant death are being reviewed at monthly level at every institute. That is going to the state headquarters. State is also reviewing that. If suppose there is any found that any doctor has made any fault, he is not negligent. It may be a fault. Nobody is involved. As the court act of fraud, he can be a failure, but not negligent. If we allow this one, then for this administrative action also, he will be liable in the consumer court to give compensation.
No, sir. Medical, again, negligence means lack of care. This would be far
Intentional care. That will be lack of care.
Lack of intentional care, and therefore negligence will be lack of care.
Okay, getting everything free is a consumer. The answer is no. He is not paying anything. Everything he is getting
Maybe
free
a
is
nominal
a
registration
consumer.
fee.
That is nominal. That is that. But
According to the law that is in place, a nominal, even if there's somebody who's paying a nominal registration fee and nothing beyond it, for nothing beyond for the services, he will not be a consumer. That's what the law is. The law is.
No, madam. This explanation by the Supreme Court
For example, you
this
have
is
a
for the
doctor in a
beneficiary.
government hospital.
He may not be a consumer. It is a beneficiary as he is, the service was given to him. So the beneficiary can claim. So legal aspect is there.
No, not in consumer court.
Not in consumer court. They
Not
can go
in
to civil
consumer case,
cases.
sir. Not in consumer court. He can go to civil court. Not
He
in
can go to
consumer
civil
court.
court.
Yes, sir. Correct. So that's what you wanted. That at least
Sir, that is, even if he is a beneficiary for that service sector, that is a consumer.
No, sir, no. You ask, she is a lawyer.
Sir, under the law.
Sir, this is the Act 2011, Amendment Act is there.
Sir,
Where they have said this thing should be removed.
Just should be removed. It's not in place right now. If it's a bill, it is not in place right now. If it's a recommendation, it is not in place right now. Under today's law, which is there was a case. It's a 1995 case where it has been said that when a person is going to a government hospital and there is no fees that is being charged, even if for registration if there is a fees being charged, that person is not a consumer. Hence, he cannot, if tomorrow there is something that happens, he cannot go to a consumer court. He can, the only remedy is under civil court. That's what the law
But
says.
if some patients are being charged for some services,
Why are we discussing?
Why are we discussing?
Why are we discussing it then?
No, sir, I think this is what the law is in place. I think there was a discrepancy within two people.
Nominal fees, all government hospitals are charging nominal, they are not for profit making, right? So if it is not applicable, why have we discussed it?
Then
wait a minute.
No, sir, I'm saying this is a recommendation.
There is a catch there. The same court, the same judgment has said, if some patients are being charged for some services, then the whole hospital comes under the purview of the Consumer Protection Act, even for the free patients.
correct. And because what we said,
Our charging for
because
patient,
the
not charging
law
for
has
us.
to have 15% rebate. So what they said, sir, look, we are not charging. So even if a free patient goes in just cause, 85% of the patients are being charged 15 now, even they will be consumer because they are cross subsidizing. Those who are being paid are wrong.
And going beyond that,
Correct.
just go to example verification.
In the government hospital, who cross subsidizing?
See, I'll explain the lacuna. Lacuna is, if I go to a government hospital, which is not paying any, where I don't have to pay anything, nobody pays. And if there is deficiency of service there, if there is medical negligence in the hospital, should that be justified because I'm not
This charging of service business, railways don't charge anything. But those services are covered under Consumer Protection Act because it is a perquisite.
Because they are charging for it.
They are charging for it.
They are railways are talking medical services.
railway hospitals.
Railway hospitals. I am not talking of railway tickets. I am talking of railway hospitals. They are providing free services to their employees. But because it is a perquisite given to the employees, though the employees are not paying directly at the hospital, they are covered under Consumer Protection Act. So this whole business of whether it is charged at the time of availing service doesn't stand good.
Correct. That's why our recommendation is that there has to be no bar of
Then you are putting doctors further in. Government doctors into private.
No, that's what
एक
then
मिनट में आप सुनिए
another kind of check and balance that you're talking about is instead of
See, if all government hospitals without various liability government के आता तो नहीं आते
आप ये बताइए कि doctors are already under the information and they can always go for criminal cases, they can go for civil cases. Why do the problem क्या है?
criminal case is not under the ambit of
Correct.
discussion.
Correct.
So recommendation
What he
is
says that should he keep quiet if there is negligence? I say no. He can always go to civil court. If there is criminal negligence, he can go to
Sir, if I may
why
put
I
it
should not get the benefit of a simpler code because I'm paying the taxes जिसकी वजह से सारा कुछ government hospital चल रहा है
तो हमारा वो टैक्स सर आप आके देखिए कौन आते हैं हमारे पास
कुछ तो पे करते ही होंगे ना वो indirect taxes भी भरते हैं direct taxes भी भरते हैं
Sir, that will not give the right status.
That's what
This is
And
what
the lawmaker will not accept this kind of a recommendation.
it is already exists. What the law exists that those who are not paying charges, they are not consumers. Law has already accepted it. Why you want to change it and make it difficult for government supply?
समझिए जैसे ऑल इंडिया इंस्टीट्यूट है पुराना है
जी
their private rooms are being paid
correct.
so the whole hospital is under
No,
it is not
so there is a medical law case if you've seen. That's what it says. That 10% अगर आपने free beds में है, but because 90% people are paying for it, so that 10% indirectly they
even
will
90% of the free है
It is not otherwise.
Just a second.
Please correct it.
AIMS is under Consumer Protection Act.
Yeah.
Yes.
CGH is under Consumer Protection Act.
Railways are under Consumer Protection Act.
Sir, just a second. So that's what the point remains, that because there's a huge discrepancy today on the law of what is services charged के लिए आप पैसा कहाँ से आ रहा है. There are some cases in which it said even if indirectly it's coming, it should be under Consumer Protection Act. There are some cases in which
प्रॉब्लम
it
क्या होता है
says
सर कि जब सर्विस अंडर बीच गवर्नमेंट डॉक्टर्स इट्स वेरी नाइस टू से दैट सबको होना चाहिए 10 केसेस चले जाएं 15 केसेस अगेंस्ट वन गवर्नमेंट हॉस्पिटल अगेंस्ट 10 डॉक्टर्स विल compromise the treatment because he won't be available to give treatment to 100 other patients.
Sir, if I may say, this all has
We are in
been
agreement with you. हम सब ये कह रहे
That's
हैं
what we are
कि
saying.
suppose अगर गवर्नमेंट हॉस्पिटल्स में पेरेंट्स लाइबिलिटी गवर्नमेंट में जाती है, ये हम रिकमेंडेशन देते हैं, डॉक्टर को प्रेशर हट गया कि नहीं है?
साहब डॉक्टर लेकिन गवर्नमेंट छोड़ती है डॉक्टरों को
वो डिपार्टमेंटल एक्शन लेंगे, अगर डॉक्टर वो डिपार्टमेंटल एक्शन में कुछ होगी
So what we can do is, in case of government hospitals, the liability prima facie should be on the government hospital. It is on the complainant's burden to show that there has been a negligence personally on part of the doctor. That is when a doctor's liability will come into place in government hospitals. That is some kind of recommendation that we can give. That under there would be a presumption of law that when there is a case against government hospital and government doctor, the first liability will be taken by the government hospital unless it is proved on record by provision of law that there exists some serious negligence on part of the government doctor, is where a doctor's liability comes into place personally.
Yeah, that's it.
That is a check and balance that we can attempt to put in place.
and I will decide.
Sir, this is a recommendation, sir. Like every other recommendation, this is a recommendation.
Who will decide this?
Exactly, that is where court comes in place. There has to be a proper evidence.
onus will be on the complainant to prove that.
Otherwise, under presumption of law, what we will do is the recommendation can be that only government hospital should be held liable. Then it's on the onus of the complainant to show that the doctor personally has been negligent.
Madam, there is a classical judgment from the National Consumer Court. Once a person was traveling in railway and he became sick. Railway announced if there is any doctor, please give the service. And the service was given by the doctor. Then the railway authority removed the patient to a hospital, not to the nearest one, to a super specialty or to a specialty hospital. And the patient died. Then they charged the railway authority for this. And the doctor was also sued in this one. Then the National Consumer Court says, yes, doctor will be liable, but he has advised to immediate hospitalization. But railway authority failed to do that at the nearest point. So railway authority is charged, not the doctor.
That is the secret of what we are saying.
Sir, next time I'm not going to declare because we have a paucity of time. The next
Implementing the Supreme Court's dictat in Samira Kohli's case, simple consent forms needed. The issue I think is Samira Kohli's case it's well accepted. The consent should be from the patient himself rather than from the relatives. It should be a specific consent. But of late we are finding that the consent forms are increasing. They're becoming very lengthy and they're all typed and printed forms. Means nothing in fact, and the patient is just asked to sign. So to make it rational, can we have something, some mechanism by which the forms are small and more meaningful? For
also,
example,
I think we have to consider between a real consent and informed consent. I think today Indian law is in terms with UK law, unlike in the United States where there's a lengthy bunch of papers which is literally read out to a patient and then he is expected to sign irrespective of whether he is understanding or not. So that is something that we need to consider, considering the kind of patients that we have in government hospitals. Whether they are equipped enough to understand the intricacies of the surgery or the operation or the procedure that are going to be undergoing. So what is the kind of consent that is required in such cases? What is the correct or necessitated or requisite information that is supposed to be given to the patient in a very precise manner?
What are the standards in
In
UK?
So in UK, And these are the 4 or 5 guidelines on the basis of which their consent is defined.
What happens? Applying all these guidelines in every surgical procedure becomes very difficult. Therefore, the recommendation was that it should be chota, squarely and fairly applicable in most of the cases, wherein the unit heads or the surgeons are not burdened with, drafting the special consent. Otherwise, you have to have a specified consent for specific patient. So, they should be, absorbed with this responsibility and something fairly applicable. Chota half page का होना चाहिए. That's what the recommendation was from the government doctor in the last. So
it's not so much a question of size. I would certainly stress that it has to be a specific consent.
Adopted for different countries. Some say that at a time when the patient is admitted, you are supposed to take the consent of the patient. Because you will be giving some injections, you will be giving some medication, some procedure will be done. Then the surgery part. Then if the patient is critical, you have to take an informed consent. Then there is a high risk consent. Within consent, there are different types. So exactly that has to be defined and it has to be categorically.
We cannot dilute the basic doctrine of informed consent. Wherever there is any potential for some harm occurring to the patient, he is supposed to be informed of all the details. What all the details could be, they can be summed up in 5 or 6 sentences. So those essential sentences have to be there. Other than that, maybe you are doing a laparoscopic hernia. You have to provide some information of that. That can be by way of leaflets or something. But the basic consent can still be made short in 5-6 sentences. They may be printed or handwritten, that is debatable. But I would suggest that the main element of that consent, even if it is printed, that should be handwritten. Maybe the name of the procedure, the risks involved, if there is a possibility of death during surgery, if there is a possibility of removal of an organ, those essential things should be handwritten.
Sir, but in a country like India, where most of the people in government hospitals are illiterate, do not even know to write, is that something that is practical to implement?
The patients who are literate, let them write. Patients who are not literate, somebody else, some coordinator, somebody can write it for him and say that I have been read out whatever has been written, and it's only a question of 5-6 sentences. And that will be a very authentic and meaningful consent, even though it is very short.
There is a question. Once MCI has circulated one drug, where the patient is also found certain information, whether he is having epilepsy, whether he is asthmatic, whether he is having an allergy or like that. But ultimately that was not fulfilled. Right today, as the bank, when we are hiring employees, our national
Let's
bank.
not mix up the duties of the patient with consent. That's two different topics.
No, sir. There is a relation. If the patient hides, then how that gives us, give me the protection that I have said I have given them all these things?
That is duties of the patient.
Dr. Pathak was right in saying that even for a simple procedure like a hernia, we cannot have a consent of 5 minutes. Because at one point we are saying that each and every side effects, complications, have to be explained. Because what complaints we do get from patients which go to the consumer protection forum is, doctor ने हमको कुछ बताया नहीं, and the doctor says कि मैंने सब बताया था. So are we supposed to keep video recordings for each and every patient? That can't be done. But there's the most common complaint which comes is doctor ने मेरे साथ कोई बात ही नहीं किया, उसने मुझे कुछ बताया नहीं. And the doctor comes and says मैंने सारी चीजें बताई हैं, भैया ये ऑल्टरनेटिव है, भैया ये हो सकता है, आज नहीं हुआ 7 दिन बाद हो सकता है.
So what recommendation we can give is there will be 2 witnesses, one from the family of
That is
the
already there.
and second
No
would
consent
be
is
from
valid without 2
the
witnesses.
and second person would be from the same hospital.
The solution that I suggested was,
So consent rates also may be changing in the government, because the consent rates may be changing every day. So the unit chief may not be coming at the time of admission. So it will be admitted under the unit chief. And if the
Second
consent
is
consent is taken by some resident or something else, someone else. So then also there may be chances that this doctor did come
only reason.
and explained. I never seen him, so that I haven't given any consent to him. That is one problem. Another problem is that in emergency situations, so what it turned out to be, we can't say. For a patient coming unconscious state, it may be stroke or it may be epilepsy or anything. So for which disease we have to take the consent is an issue. The patient brought in an unconscious state.
So ma'am.
So for example, it may be a stroke.
So let's.
It may be an epilepsy.
Just a second. If
So
we may just,
unless certain investigations are done, we cannot pick up what
so if
specific
I may
disease.
just categorize, you probably want two kind of issues that are to be solved. A, in issues there are cases where the doctors themselves do not commute or communicate with the patients. A, this is one.
Yes.
Second is when the patient comes in an unconscious state where he is not in a condition to give his consent.
Then for
No,
that
ma'am,
it's
If
also-
we may first
So what
just
exactly
address
is-
the first issue,
So
first
for
to come
the
to the
patient
second.
is just coming in an unconscious state.
Right.
But we cannot specify what type of consent we have to
Okay.
take.
So first, let's just first issue. If we may segregate
What is
both are
plan-
different
plan
issues.
statement?
We were talking of, you started the point with that the consent is being taken in a typewritten form for each and every procedure which has to be done on the patient. We started at that point. And then the issue came of a handwritten consent to be given by a patient. Correct? My answer was to that point. So that's the only reason, because it cannot be done in 5 lines, because it cannot be done in the way we were talking. That's the only reason. There is a format available with each and every hospital. That's the consent form for each and every procedure which is done. At least I'm a surgeon, surgically, on
Right, but
the
the
patient
problem-
and the patient's
Right, but
signs on it.
at this the problem you are facing is that when it comes to court, the patient outrightly denies that no, भाई मेरे को तो कुछ बताया नहीं गया था. So we need to come up with a regular rule of that. So we need to.
See, let me clarify this point. See, the question is one, the doctrine of consent cannot be diluted. Number two, consents are very lengthy. And it's not only a question of one page. There's many hospitals which have consent running into 4 or 5 pages. And there is a talk about video consent and all those things. I would suggest that if you want to balance out the things, let's divide the consent into two forms, two parts. One, a leaflet describing all the information, say a laparoscopic hernia or a thyroidectomy or whatever. You give all the relevant information in the and the statistics, whatever you want to inform in the language, maybe Hindi, English or Punjabi or whatever, and another consent form where the patient may be typewritten or printed or handwritten, immaterial. That should be a small consent where he certifies that he has read the contents of that leaflet, where he says that it has been read over to me all these points, and there are 5 or 6 material points which have to be included in that. I have been told the diagnosis, I have been told what procedure I am going to, nature of the procedure, the benefits that I am expected, and the risks and the alternate, and all those 5 or 6 points which are important. It's not checklist. It's not checklist. It's not checklist.
It is a kind of
It is the contents of the basic relevant information that the patient wants to know. And in a way, there are two basic concepts of a consent. It's a patient-centric consent and a doctor-centric consent. The question that you asked about the UK, you have a doctor-centric consent. What a doctor feels that the patient needs to know. He will give that information which he thinks that my patient needs to know. In US, it is a patient-centric consent. It's the patient who says, I want to know everything. I want to know all the statistics. I want to know how many surgeries you have performed. I want to know everything. So that is a patient-centric consent. So in US, you have a very lengthy consent.
So what do you think what we should have?
We should divide it into two. One, a leaflet kind of a thing. Say hernias or thyroid or breast or whatever, you have separate leaflets which have all important information, and all patients undergoing surgery, they are given that leaflet, they are given time to study that, they can discuss it with the doctor, treating physician or the RMO.
But sir, in
And
other
then
hospitals is this
sign on that.
You can have posters or maybe.
And how do I go in
one page consent, where one of the sentences will be, I have read the contents of the leaflet provided to me. So that is over.
Only one sentence should be added to the existing form, and I have been handed over a leaflet which explains the pros and cons of the existing procedure and the alternatives available.
So, but at the end of the day, we talk about government hospitals. Is this practical enough?
Yes, I know.
Is this practical?
No, I differ. Handing out a leaflet is not a big thing. It is only
That is a very rational way of it.
But is it enough for the patients to understand what they are going through? The kind of patients that we have at government hospitals, are they equipped enough to even go through those leaflets and understand what they are doing?
What?
It can have different local languages.
Yes.
One.
Yes.
Second is the common problem of every one of us will agree is none of the doctors take consent. It is left to the junior most doctor.
Goes outside,
Yes, and what does that go? And many a time it happens while taking him, leaving him inside the OT.
So here then MCI has to come into play and proper guidelines have to be set up regarding who is it to be
That is there. It is the treating physician who has to take the consent. He must sign the consent form to show that he has explained. It is his duty to explain the information to the patient.
And what the
government hospitals, there is aims, they spend 10,000 rupees per patient per day. That's what their budget is, and they can afford to do this. Then we have our hospital, civil hospital, Bombay, where we spend 3,500 per patient per day. And then there is district hospital where the government spend 500 rupees per patient per day. And you want to have a guideline applicable similarly at all the hospitals.
No, because patients at
all the hospitals,
they
if we have to change something,
I mean, if you
we have to
form
change something,
earlier
we
as
have
other
to
hospitals.
district mindset. We have to change our mindset. If we want to change something, if we want to do something, we have to bring in some substantial change. You just can't refuse.
All patients.
But what about surgeries? But there are vast number of other medical procedures also for which we require to take
So we
consent.
have to make a start. Department wise, we can always be. It's just a matter of giving it to a resident. A resident can prepare these guidelines in one day.
So every department can come up with its own leaflet of basic things that are required for surgery.
You can print a handout in 10 paisa. You don't need thousands of rupees to print a leaflet.
Now can we have a small recommendation that NRHM or NHM, now it's NHM, should come consent forms for common procedures in all government Uniform procedure, not consent.
Consent form can be the same, only the leaflets will differ. Only the instructions will differ. The consent form has to be the same.
Can I complete? Okay. Now there are two parts we have discussed. A is leaflet, B is consent. So they should come out for all the procedures. Common leaflet for all over the country. They should have. And NHM has a lot of funds. So at the state level, NHM and through NRHM they can print and give it to all the government from this necessary to this A. B. There will be another small form bearing name of the procedure, language which understand Marathi, Hindi, and plus signature. Now what will happen when NHM drafts and sends to all the state governments? They will have all those printed in their own languages. They will be available. Not only that, if it is to be made available and applicable, it can be applicable in the private. So then big burden will go off from the government. Something of that sort can be done. It can be done and because problem is वो civil सर्जन बोले मेरे पास फंड कहाँ है कौन से फंड से मैं छापूँ so let it be NHM, NRHM, state, local language and right from your state hospital level to the PHC.
Fund to government से आता है.
आज हमको ये भी देखना है कि NHM सारे गाइडलाइन NHM आते हैं तो NHM को पूरी कंट्री में करना है तो अगर आप ये
इसके अंदर एडमिट हुआ
या फिर एक सीनियर रेसिडेंट जो है जो एमबीबीएस कर चुका है उसका रजिस्ट्रेशन वो भी ट्रीटिंग फिजिशियन वो क्यों नहीं ले सकते?
That's to be consulted.
कंसल्टेंट कभी-कभी सर आप गवर्नमेंट
वही
ये एमबीबीएस से सीनियर
साइन करेगा उससे उसके एक और फायदा होता है।
आप ट्रीटिंग फिजिशियन
इसका मैं एक और फायदा बताता हूँ कि मैंने टाइम अगर आप ऑडिट करें कंसेंट फॉर्म को पिछले 1 साल 2 साल की मैंने अगर कंसेंट फॉर्म का इनकम ये फॉर्म इनकम्प्लीट अगर कंसल्टेंट ने साइन करना है तो रेजिडेंट उसको कंप्लीट कर भी गया है compliance will be better
but the responsibility will be there.
How do you
उसकी परिभाषा
But sir, how do we implement this? As we heard that most of the cases what happens is that peers go and take the signature and come back. How do you implement it in a strict manner is the question.
As I rightly said, if the consultant is signing the form, he is automatically responsible.
on his behalf anybody can take signature. Taking signature is a very
But he is accountable. He is accountable.
Must countersign it that, or there has to be some kind of declaration also on part of the resident who is signing it or the doctor who is signing it that I have informed.
we are specifically addressing the issue of consent, not the entire documentation. The point is valid. सभी documentation uniform होगा तो बड़ा अच्छा है. लेकिन at this forum we are just discussing about the consent.
Excuse me, sir. Can I be sir is saying that actually residents are different entity and consultant. There is assistant professor, associate professor. They are all MD. They are all class ones, say for example. And residents are different. Whatever work resident has to do, they have to do, and consultant has to do, they have to do. In government, we have enough number of consultants. You are saying so many I am from government. In medicine department, there are 18 consultants. They do emergency for 1 day. The OPD is overburdened only for 1 day. Rest of the 6 days they are relatively free. That is our. So overburden means not distribution of labor, not better managed hospital, the hospital and the that are the issues. So residents are able to be held responsible. And even for night, consultant is on duty. He is on emergency duty. If he doesn't come from his home for anything, it is his responsibility. Resident is never to be responsible. As sir says, you are given instruction, but it is followed or not, it is to be seen by consultant only. It is not that उसने बोल दिया कि हो जाना चाहिए नहीं हुआ, he has to see everything. हमारे वहाँ जैसे लेफ्ट राइट का प्रॉब्लम हुआ था, रॉन्ग साइड ऑपरेटेड, कंसल्टेंट को फोन किया गया, रेसिडेंट ने बोला मैं ऑपरेट करता हूँ, वो नहीं आया, he was on emergency duty, he should have come, he should have ideally been in campus, why is at home on emergency, although he has not come, the operator, it was operator
So
on
the exceptional cases will always remain at the end.
yeah, so no, all assistant professor, associated professor,
The same scenario is there.
assistant, associated professor, all same
But
responsibility.
they
Everybody
should
should
say
have-
this is the consultant has signed the form.
Exactly, consultant or whoever is the person.
He signed the form.
Yes,
So whatever you are saying, that decision has already been taken.
Yeah, that
So
is-
now let's what we can add is one kind of declaration from the person in charge also, or doctor in charge also, and I have made sure that the requisite information has been passed on to the patient. Some kind of declaration on part of the doctor so that there is some responsibility that is
So
attributed
has
to
to be
the
signed by
Signature will
ये जो इन्होंने जो बोला है जजमेंट लिखना कि on the consent form maybe chief of the surgical team or consultant is also signed. That's true that he has gone through, he got the signature, he verified that it is already been signed by the patient and then he went ahead with the procedure. So that is fine. आगे बढ़ेंगे सर.
आगे अब एक लास्ट इशू हमारा नीड टू फ्रेम स्टैट्यूटरी गाइडलाइंस फॉर गिविंग डिसेबिलिटी सर्टिफिकेट्स. Sometimes we have controversies and issues related to disability certificates, and many times the decisions or the opinions are very subjective. तो इसके बारे में
also.
As far as ESIS is concerned, because we have got a lot of patients of employment injury, they have to practically we give compensation based upon the degree of disability. So we quantify in percentage, whether it is 2% to 100%. So we have a definitive, very objective set of guidelines. In case if one phalanx is gone, we say it is 1%. If it is right hand, then it is 2%.
Can
It
you
is
share
thumb.
with us?
It is there, it is on the net. It is public domain, it is part of the
available on its website.
Yes.
All the procedure, the competent authority who can give this disability certificate, criteria for giving the disability wise. There are 6 disabilities: vision, hearing, locomotor, mental. All these disabilities have been defined as on date. This act is under revision. As on date, there are 6 disabilities, and then there are 6 sets of criteria according to which how much disability can be granted, procedure, authorities who can give the certificates, all defined. It's all available on the net.
And the appeal mechanism, in case if somebody is not satisfied with a particular authority, what appeal he can go into.
Everything
But
is
because ESI is one of the important organization which is giving these certificates. We have this right. ESI
We recommend that guidelines should be followed across the country.
No, sir, one point I want to add what he has said, that's absolutely correct. But there are 3 sets of guidelines, one for ESI, one for PWD Act, and another for INCOR.
There are all sets.
There is only one set of guideline, and only one is to be applicable, which is the Department of Disability Affairs, and we have no choice not to follow that.
No, that's PWD Act.
Yes,
but ESI Compulsory Act is
sir, ESI has got nothing to do with this. We have to follow. This PWD Act. We have to follow it. Despite only the authorities are different. You can have your state authorities, you have your central government authorities like hospitals, you have designated hospitals, and even the hospitals, what boards are to be constituted, how the doctors is to say that. Everything is defined to the last minute
Is it
detail.
under review? Is it under review?
Review, this is the only problem. What he is saying, this is the only problem. It has been reviewed n number of times. Some authorities have not received the latest version. Some authorities, it is the duty of the Ministry of Social Justice to disseminate this information.
Website पे है.
Website पे है. Website पे है. Ministry of Social Justice and Empowerment
बनाता है and then different organization would adopt that.
If I may state, I don't know if, from what I've read about the industry, there's one problem that is faced is जैसे कई बार motor vehicles compensation tribunal के अंदर कई बार tribunal says within 2 months give us a report. But there are certain kinds of disabilities that probably after 6 months will be something else.
Even this is there, whether it is a corporate or it's a permanent disability, it is there.
Again, that's why all disability certificate is given only when it is certified this is permanent. And if it is correctable, it is withheld, and you can say that it will be observed after 6 months.
Disability certificate is given, but it is called as TD, temporary disability.
Review after 6 months.
Yeah, it is reviewed and final disability has to be permanent.
We have to go by that. We cannot have separate guidelines for ESI and separate for CGHS and separate for
No, I think we should recommend that these guidelines should be made uniform across.
Sir,
They should be adopted by all.
we have no choice but to follow this. It is a law. It is a law. We have no choice but to follow this.
They are already adopted.
They are already adopted.
So no controversy.
Yeah, it should not have a black reflected in the point of discussion itself.
It should be disseminated so that everybody is educated.
I think sir has a point.
Sir, I will understand whether this is for ICF or WHO, where disability is another part. Level 1, level 2, level 3, level 4. But is this for made for that one or for the PWA? I can understand this thing.
So I don't get what you say.
There is WHO, there is a one guideline ICF, International Classification of Disability.
We are not recommending for WHO, this is for our guideline.
That is already there. Every country needs to follow that.
Now,
Sir, such guidelines,
can I give you
such guidelines are only recommendatory. We are not bound by WHO guidelines entirely. We are bound by PWD Act.
I don't understand why this point is here. I mean, for WHO guideline or for PWD.
Can I answer?
Why PWD Act?
Can I answer? One of the members in the earlier meeting had said that I received many times letters and directives from the motor driver that give certificate because they will decide the compensation. Now, when it is progressive and it is not permanent, I cannot give. So there has to be some clear-cut guideline about that. That's what we want to see. Therefore, this point was added. Now, what you thought? I mean, you can give your own suggestions, that whenever the disability is progressive and you are asked that within 2 months you give the certificate, in your certificate you can say it is progressive, hence right now it cannot be confirmed. And maybe after 6 months, 1 year or whatever time, it can be confirmed. Accordingly, you give the certificate. You don't have to, not to give certificate is not an option, then give certificate and say what is the fee. So that's what.
Sir, in the criteria that are available, there is a forma where it gives a disability certificate. And in that, it is already mentioned whether it is a temporary or permanent disability. And how frequently we need to review the patient to give for and to reassess the disability. It is there in the forma itself. So there should be no controversy on this.
No ambiguity.
If I can interrupt for a moment, I would like to just announce Dr. Ambomani Ramadas is here for this session for some time. So probably
Welcome, sir.
So we're discussing about the problem of disability certificates being given. So a lot of times what happens is that tribunals are ordered doctors to give a disability certificate say within 2 months, within 3 months. But our problem is that at times it cannot be assessed within that span of time as to what is the percentage of disability and accordingly what kind of compensation is to be granted. So if you may please shed some light.
just 1 minute. For those who are not aware, Dr. Ramadas is a former Union Health Minister and a sitting MP. So I think he can share a lot of, and he has been instrumental in getting a lot of things done in Parliament. We can have some insights.
This is go on in discussion and join later, sir.
I would like to add one thing. As Sir rightly said, there are 6 types of disabilities given. There is something called as communication of disability in this. Some might have visual, auditory, it could be psychomotor, various. Some of the disabilities at the time of giving certificate might be permanent in nature, some might be progressive. So while giving a certificate, one can state that these disabilities are permanent in nature and the percentage is this. You might have to actually commute 2 or 3 of them. The rest which are progressive, you can similarly mention they are progressive in nature. Therefore, related to whether they will be permanent or treatable cannot be commented on. So this type of certificate also can be given.
In such cases also, if the doctors can recommend that it is probably after 7 months or 8 months that the proper or the exact amount of disability can be certified.
Sorry, the certificate has got all those points. Whether it is temporary or permanent.
I think there is no controversy about it.
Yeah, there is no controversy at all.
Very elaborate. Normas are there.
How is it that the compensation should be calculated at the end of the day? That is also something that we need to take care of.
How calculate? We don't have that is also there.
That is also
correct.
That is also there.
What is the amount of compensation that
What
is
happens
paid?
when the judge is sitting in the local tribunal?
That's what my question is. That progressive declaration made.
I have not finalized the compensation because the permanent disability certificate will be available after 6 months, 1 year, 1.5 years. If that timeline is given, then it will be helpful for him to dispose of the case.
You can order interim.
He can order interim and then ask the when you come back
When you issue the certificate, mention that the patient is to be reviewed after say period of 6 months.
Correct.
Or
That's not
there in the certificate.
I think what we need to do is that the available guidelines need to be distributed and we need to educate all.
People must be aware of those guidelines. Those guidelines are quite robust. Those guidelines are very clear.
Whenever like I have seen in US and they have a new act, along with the act, they have roadmap of implementation of that. When they come out with the training guidelines and modules on this various amendments, they go to the Public Defenders Institute, they go to the law colleges, they go to medical schools, and they have a roadmap how we are going to implement these amendments in cases. What happens with here is that we amend the act, we enact the act, but we don't have the roadmap of educating all the stakeholders into implementation. Like execution is, so you should have a roadmap of execution. Perhaps you have a very good guideline, but its implementation roadmap has not been decided. So maybe you can have a training module for these, guidelines that has to go to all the medical colleges, so that concerned stakeholders are trained. And here again, this step is also existing, but unfortunately, what happens is when these things are disseminated down the line, director sitting in his room gets a thing, he marks deputy director. Deputy director marks it to assistant director. Assistant director marks it to administrative officer. Administrative marks it to the UDC. UDC marks it to LDC. LD files it to the branch. Nobody challenges को हमने भेजा था कहाँ दिया? कोई पूछता नहीं है कि वो हमने भेजी थी गाइडलाइन, वो फाइल पे तो पूरा करो। सर आपके पास गाइडलाइन होती है, ट्रेनिंग मॉड्यूल्स नहीं होते। This is usually the lacuna lies.
I think we should hear from the former minister something. He has got a lot of experience and in his he can share that with us. Please.
My colleague here could shed more light on this issue, right? About disability certificates, I think we are discussing that, or you are discussing the entirety of it.
You start with disability certificate and then just pick up the other 3 points.
To be candid enough about the disability certificate, he is a more technical person than me, so that I have checked all your technical details. So that already there are guidelines which needs to be awareness needs to be. That's the whole point. What is there, everything is there, and the also is robust, it's there. Coming back to issues about removing government hospitals, medical colleges, which is the Indian Protection Act. What are the discussions?
So we went through the
No,
process.
or you finished this
We finished.
Completed all the 4 experiments.
Sure.
Just in case you can give the gist of what we have discussed.
So sir, the first and second are little relatable. Vicarious liability of government hospitals and government doctors, and government hospital doctors under Consumer Protection Act. We discussed about the law in place right now, because when there's a free service that is rendered in a government hospital, they are not under the Consumer Protection Act. We realize that there's an ambiguity regarding what is a free service. It has been interpreted by the courts in different ways. So one of the first suggestions of this panel discussion was that this entire discretion of free service or not should be done away with. Any kind of service, irrespective of whether money is charged or not in the government hospital, should be under Consumer Protection Act. However, realizing that such things would, shoot up the cases in a very high manner. To counter those things, we've come up with certain suggestions. That understanding that government doctors work under a lot of pressure, the infrastructure, the resources are not as well equipped as in private hospitals. As a matter of rule, as a presumption of law, first, it's the government that should be held liable in such cases, and it should be on the complainant or on the patient to prove that there's some kind of personal negligence of the government doctor, and only then should government doctors be personally liable to pay or to contribute to the compensation that is given out to the patient. That is one of the suggestions that we came up with. Also, another thing that we came up with is that there has to be some kind of mechanism coming into the consumer court. So there has to be probably a statutory bar for patients coming into consumer court. There has to be one independent ombudsman kind of an authority, which has to be mandatorily gone into first, and only then should a person be entitled to reach the consumer court, because we realize there are a lot of frivolous cases that are coming into place. So at times probably the patient thinks that this is something should be done, but under prudent manner the hospital or the doctor has given him a certain guideline, but just because the patient is not satisfied enough, he file a consumer case. That is there. Even when a consumer case is filed, there has to be an expert committee or an expert panel that has to be there, whose suggestions will be recommendatory in nature given to the consumer court, and the consumer court should take a call regarding whether they'll be binding or they'll be going by the recommendations of the expert committee or not, and then come into the decision, because we realize that the consumer court itself is not equipped enough to exactly deal with cases regarding medical negligence. Yes, and of course, as the law in place is that in case the medical consumer court feels that no, there is more detail and the evidence has to be done in a more detailed manner, it will be relegated from a consumer court case to a proper civil case where a proper evidence mechanism has to be taken into place.
And one more thing, as a deterrent we said that...
Also sir, there has to be, we have to come into place with certain kind of procedure to deter people from instituting frivolous complaints. So there should be a penalty clause that should be added in the act itself, which may be, for example, this is the suggestion that say if the court feels that yes, this is a frivolous case and the complainant has not come to court with clean hands, as a penalty 10% of the amount claimed is to be paid by the complainant as a cost to the court. However, there were certain suggestions that this may be a regressive policy. Yes, but that's what we said, that such the decision-making authority has to keep the bar such high that only if they feel that the institution of the case has been done with the intention to harass the doctor or to...
Rarest of the rare cases.
Yeah, to just waste the court's time.
I don't think they can go through this. That be a civil court. Prove that the patient is to harass the doctor has intentional thing. I don't think the consumer court has the power to prove it.
Right, understandable, because consumer court is a quasi-judicial tribunal. In case if somebody can shed
And sir,
light on
you
this.
were the one who started this NRHM and all, and the Rogi Kalyan Samiti. So now a lot of user charges are being charged by Rogi Kalyan Samiti, and that corpus is going to the Rogi Kalyan Samiti fund. So in that respect, whether the civil hospital person, because the properties of the civil hospital has been handed by the government to the Rogi Kalyan Samiti, so that they can charge the user. Means legally, whether the government is charging those fees or the Rogi Kalyan Samiti is charging them. So in case, who is liable for penal action? That was my point.
See, it depends on the laws in each state. So Tamil Nadu has got a different answer. Maharashtra has got a different answer. Bihar has got a different answer. But the intention is the same. The intention is to help out. Rogi Kalyan Samiti for a district headquarter hospital, where the government contributes doctors.
Yes.
And then the state policy, that state could take a policy, say that that could be free treatment, or they could use a charge for some investigations or something. So it depends on how much money the state is going to contribute as well. For us, I mean, at the time when I got in this NRHM, the intention was there to, because in a sub-center or a PHC, at the time a doctor wanting a syringe, he has to an Indian has to go to the CHC, then go to the district headquarters, then from there we go to the state, and it takes 3 months for a doctor. So that time we said that let us have parked some funds for basic issues, and so that he could, in a day he could decide and buy what he wants. Going back to that, this money was for what plans, what requirements they wanted. Earlier, the state used to decide what the PHC wants.
It was the other way around.
Sitting in Bombay or Mumbai, people in somewhere near Nagpur, some PHC Nagpur, they say, okay, Nagpur PHC wants this. So that we had to turn around and say that, no, what they want, they would let them do it. So that was the, so whether it is free treatment or not, the government hospitals, whether they could be bought into the Consumer Protection Act. I mean, this is a contentious issue.
Yes,
we ask the states that they should definitely, on the, they will not want to be part of it. And the government, as it is, they are doing a lot of service. And only the government setup is there in the rural areas. 81% of the experts, specialists are there in the urban areas. Only 18%, 19% are there posted in the rural areas. It's a huge problem per state. And at this time, taxing the government, already burdened the government into one more, bringing them into the ambit of this also. It's going to become to taxation. And we could discuss these things. But then, how many of you from the government sector? So I think this needs a lot more discussion and deliberation.
In fact, sir, to begin with, like, my opinion was that government setups should not be under the
Blanket ban.
I will give you the reason. Because the reasoning given was that whenever even you are charging 10% of the patient, they are not subsidizing for other patients. It is true in corporate hospitals where 15% are free, 85% are paying, and they are not subsidized. Here, patient pays not even 5% of what is being spent. And taxing, further taxing, and then it will come from what budget. If health budget, if this compensation is coming from health budget, you are somewhere compromising the health infrastructure in the country. In that state or in that district. So, I mean, it is not a good idea. But as a principle of, whatever.
It's in case if to come up with such a stringent act, blanket ban. No, agree, filing will be more, but sir, in order to come up with such a stringent action that no government hospital will come under Consumer Protection Act, there has to be that kind of locus available for us to, get such a thing passed. But is there certain that kind of a requirement available that government hospitals entirely should not be under the Consumer Protection Act?
And see, there is always civil courts are available.
We also know that civil remedies are
There have been a
remedy.
lot of incidences where doctors have been penalized for wrong and they have been made to pay the patients. There have been issues. But on a blanket, bringing them into the ambit, that's going to be difficult. And Dina setup, Indian setup, mentioned that nobody mentioned this, there's going to be a strike.
And we are not easing the job of the government institute actually. This whole deliberation is we are getting them into the fold of ambit of
easing the job of the doctors per se. See, when we say that there will be a presumption in law that government doctors will not be personally liable and it will be the institution who will be vicariously liable.
Ultimately, what happens is that if one man is compensation which has to go from the health budget, right? Then there has to be justification why they have to spend because certain hospital has been penalized because of those needs. There will be department. You see, you don't know how much trouble a person has going to the department employees, and perhaps 80% of the times he will not be responsible directly for that. And there will be because you don't have to spend money, blindly keep on going. Look what has happened in RTI. I have activists. Like, I had to go to that section 8 and go to judgments, and then somehow I'm expert in denying the information based upon several judgments. Otherwise, there are habitual RTI activists who are just extortionists.
That's why we have this.
So now, if you make it free that anybody can go against the government doctors, it will be misused.
The only question is the patients going to a government hospital, they also deserve quality of care and
Both of these things have to be taken hand in
not
hand.
justify
That is a different responsibility. That's a different responsibility of the government to provide and then to invest. And that is something which needs to be, that noise needs to be made continuously. Unfortunately in India, 75% of the infrastructure is in the private sector. 25% in the public sector. And the investment of health in India is total 6% of the GDP we spend for health, out of which only 0.9% is from the government, 5.1% is from the private and individual. So in this condition, again you put out this to that, and that is going to shrink further. So we need to bridge the gap between the private and the public. And for that, more investment needs. That's the investment, facilities, responsibilities, and let's say example accreditation. You accredited hospital. You bring out all these issues, documentation, a pattern. So that needs to be more done. But then blindly bringing in the consumer and the ambit of this act, that will create.
So right now, but the procedure, right now as per law, it is under the Consumer Protection Act. However, in case of free services, it is not under the Consumer Protection Act. That's the minor
Minor is major because 90%, 95% of them are free patients.
The 95%
Free patients.
5% there are good hospitals where you have patients paying good quality hospitals.
So you want to put in those remaining 95 into one, eligible. It's a very pious,
No, but sir, again, we come on to the question of how do you segregate? Like there are various issues, various cases in which it has been held that indirectly because the money is coming, hence they are under the Consumer Protection Act. So hence there has to be a categorization that needs to
Now,
come
can I
into
ask
place.
you a very stupid question? It's a very stupid question. I'm just thinking about it. If I go to eat in a restaurant and something happens to me because I've paid money for that food, that particular person, that particular restaurant is responsible for it. But if I go to a gurdwara and have that langar food, will they be responsible under Consumer Protection Act?
They are not consumers.
Right?
Not
So
direct
I'm not a
services.
consumer at a gurdwara. I'm not a consumer for a gurdwara. The situation is similar here for a government hospital and a hospital for which I'm paying for the services.
I beg to differ on these two situations because
I'm just saying I'm not asking
No,
a
no,
very stupid
no.
question, but that's my question.
I would like to ask you the same thing.
Yes, sir. Yes, sir.
As a taxpayer of this country, I have paid the government my taxes, out of which these hospitals are run as free for the poor citizens. Okay. Now, as a taxpayer, I have gone away these free services for which I have already paid. So this is indirectly. Whereas in a Gurudwara, you have not paid them. You have not entered voluntarily. Here I am entering as a master's. Probably I have already paid and the government is entitled to give me services. Therefore I enter. As a government doctor, since I am a salaried person and I have been paid to do my duty, why I should not do my duty properly?
Sir, that is the point against it. I am giving the tax for everything.
Yes.
And government is giving the salary to everyone.
Yes.
So in other cases, the Consumer Protection Act is not there, not against the police, not against other teachers. Why only health will be included? So this is not the thing.
So then
Who has stopped for one? No, not that sir. It's not a
He's not a consumer, he's not paying to get
I think this who is a consumer has this phrase has gone in judicial scrutiny for years today, and Supreme Court, National Consumer Forum has decided who is a consumer. So let us not discuss that. So I think that has been discussed. And as far as the citizen is concerned, if the service is gratuitous, if he is not paying for it, he is not a consumer. That has been defined by the Supreme Court.
Right, correct.
So majority of patients who are going in government hospitals, they are not consumers and they are not covered under consumer protection.
So,
That is very clear. Only thing is what we are trying to equate their government services with private services, and they are entitled for a better service, and that's what we are discussing. But according to COPA, a citizen going to a government hospital availing gratuitous service is not entitled to have protection under the consumer protection.
In order to just settle the controversy after the panel discussion, my simple question is to the panel that whether they are in agreement with this law that is in practice right now. So we do not want any segregation. So we do
No,
want
madam.
the segregation
Actually,
to
government
place.
hospital is not exempted from CBA.
Pardon?
Government hospital is not exempted from CBA. The hospital is
No,
cleared.
it is not exempted, sir. However, the law in place is such that if the government hospital is giving you a free service, then it is exempted from Consumer Protection Act.
Madam, this is not the free service. Question of service and this is the beneficiary. They will get the.
That is where interpretation has come into place.
The government hospital, which is been free hospital, is not under CP.
Yes.
That is sure.
Yes, VP Shanta case on
As per
1995.
existing law, it is
Existing
there.
law, it is not.
That is the
That is the status quo.
spend around 3,000 rupees per day per patient just for the indoor and other services. Ideally speaking, as per the laws, the money spent on that treatment of that patient should be borne by the cost should be borne by the insurance companies. So that time when we went to the AGM or the insurance company, so they were not very keen. But we said that if the government can make mandatory that whatever money spent by the city, so, we are Bombay Municipal Corporation or any government, the patient should be billed and the bill should go to the insurance company. And if that money comes, that will be used for upgrading the facility for accident patients. And it will be hopefully, number one, including the healthcare services. Number two, they themselves admit that afterwards they have unscrupulous bills and then they, try to get that compensation from the courts. So here, what exactly was spent on healthcare is documented, and that money should go to government because government can spend. And insurance companies are very rich; they can pay to government. You should have
question, I think very prevalent in this. So, but in such a scenario, question that pertains to us for this panel discussion is that in such cases, these cases will be under Consumer Protection Act or not. That's where I think we should be bothered. Limited to our agenda.
If they are getting money from insurance companies, they will be under this. But that money will be utilized for upgrading the facilities for trauma care, and it will be mutually beneficial. But what the practicality is that one of the general managers of insurance company said, Dr. Saab, we are happy if patient dies because I have to give one-time compensation. If he remains disabled and survives, then I will have to pay more. This is the practicality. But if we can have something, some act or whatever to make it mandatory for them to compensate the government hospitals, even private hospitals.
Today there is no act per se in that. I'm not aware of it.
There is no act.
The government hospital, there is no insurance compensation.
No, not at all. And they are supposed to. So this money which should have been spent by the insurance companies, they are pocketing them. And we are spending on the
So
care of.
because I'll tell you what the insurance contract is like. I'll indemnify you for whatever cost you incur, because you take into government hospital, the cost that you incur is lesser and the cost on paper, then there has to be a cost.
So that's what I'm saying. We bill them, but we don't charge the patient. The bill will be to the insurance company.
So that somehow I understand your sentiments, but I think let's focus on the
one more
issue agenda that we have.
Insurance in Telangana is different to Manavesli is there. So there are certain bunch of cases are coming. So they are paid even for the government. And some share will go to the DME, some share will go to even consultants also. So if that is the case, so that person may be issue a case as a consumer. Because it is not totally free.
What he is saying is each state has got its own insurance healthcare policies, programs. Government has got a chief minister.
So that is also a kind of insurance.
Like they have allocation where the government spends 1 lakh, 2 lakh, 3 lakhs, 5 lakhs. But then the issue of handling income.
Yes.
When you say that the insurance compensation for government hospitals, this money, this Adhokeshri money, should be used for the government hospitals.
But it is reversed.
But it is not. It is not. 95% of the money is used for private hospitals. It should be the opposite. If 90% money is used for the government hospital, then that money again will go inflow into the government hospital, and then they'll have a lot more facilities.
Trauma care today.
We are digressing the topic.
We are commenting that so many cases, but it's not getting.
Yeah, we stick to the topic. Actually, we are short of time.
Yes, if we may please come back to the topic. So we're in agreement with the fact that this current segregation of fee being charged, not being charged should be there in place. In addition to this, however, government doctors need to be given some kind of protection, understanding that the infrastructure, the resources that they work under are not the ideal.
Only one more suggestion was, because we are moving from this supply side model to the demand side insurance model. Every state is having some sort of insurance scheme. But the problem with these state insurance schemes is Maharashtra is having Rajiv Gandhi and Arogeshri in Andhra Pradesh. Those are totally subsidized, almost totally, all insurance premium is paid by the government. So, in case if the patient suffers or he moves under the Consumer Protection Act, with the condition that I have paid an insurance premium, I am a consumer, who gets the compensation? Whether the government should get the compensation or the patient should get the compensation. Because patient is affected, premium has been paid by the government, the patient has not paid the premium. So that aspect
The
needs
patient
some
is the
clarity.
beneficiary. He is the beneficiary. He gets it.
And then he will get it.
In some states they pay 1 rupee.
Yeah, I mean, you have to understand.
And you get a service of.
Yeah, in RSPY it was there, you pay 30 rupees, but they have specified that 30 rupees was towards the cost of the card, the biometric card.
Whatever it is, he's paying 1 rupee and he's getting a insurance of 1 lakh.
1 lakh.
He is the insured.
Because lot of states are going into that, so you have to take that aspect into consideration in regards to insurance schemes. Because almost all states have some sort of insurance model.
Right, so but taking the socio-economic condition of our state as such, I think government will have to take the brunt in such cases, and we have to probably empower these patients who are not able to afford otherwise the services.
So is government planning to increase the percentage of revenue that we have spent?
I wish.
Sir, may I ask you another question, sir?
Yes.
Sir, for the government doctors, can government consider indemnity insurance for them also, communal insurance?
No, for them.
For the government doctors. The institution itself will bear the insurance for the doctors.
Against medical cases,
There
medical
are two,
cases,
yes.
indemnifying against the medical cases. The doctors should have some kind of insurance that tomorrow in case there's a case instituted against them, they should be indemnified with such cases. That's what. Sir, but what we are saying, if we are already recommending that vicarious liability in such cases should be only on the institution, then such a indemnification is not required.
It's automatically.
It automatically comes into place with the recommendation that we have. So if I may please apprise you of the third issue that we have regarding what is consent when it comes to the Indian scenario. Samira Puri case in which court has said that it should be real consent and not informed consent. Like in the United States of America, the format that is followed is that there's a 5-6 page thing that is literally read out, exhaustive law that is read out to the patient and said. We do not go on that terms, and we following the UK policy no such, which is a general consent that is coming to form, and the recommendation that came from here is that probably the government should come out with leaflets. Every department will come with general leaflets of information which will be circulated throughout. Along with this, there will be a plain simple declaration form which will be signed by the patient, in which stating that I understand the consequences of the procedure I will be going through. I've read out, I've been informed regarding the leaflet, etc. that have been passed on to me, which will be countersigned by the doctor in charge with a declaration that requisite information has been supplied to the patient. So this is the recommendation that came out from the discussion, that this is the kind of consent that probably is workable in a country like India, especially in government hospitals.
This is only for government hospitals.
It can be for both. However, since our panel discussion,
They are protected. They have a lot of.
Maybe Canada can come out, like for, say for every procedure there will be a leaflet wherein all the alternative procedure, letter of procedure, and this everything will be drafted. And maybe the draft will be sent to all the states, wherein in their local language they shall print them. And right from the medical college to the PhD level, all these procedures
one issue we all missed out is what to do if there are patients that come in and are unconscious states like sirs, like how to address that issue. These were the 4 issues that we had broadly. Anything else, if somebody has to. So that's not the part of our there's a panel on it, but we are only on the government.
Sexual assault cases coming to government.
That's like how to say we were
On the patient or on the doctor or paralytic.
Patients coming to the hospital and what are the obligations like a drug so if we don't inform police, the doctor can be behind the bar for 6 months.
So before we disperse, can you please read out the topics about structure research?
Again, the first 2 topics, if I may say, the first 2 topics was removing government hospitals and medical colleges from ambit of Consumer Protection Act, redefining vicarious liability of doctors, teachers in government hospitals and medical colleges. Summing up these 2, we come up with the recommendations that A, the existing practice of segregation of fees should be in place. B, to understanding that the setups that government hospitals work under, in such cases, there should be a presumption in law that government doctors should not be personally held liable unless, of course, it is shown by the complainant that there has been some serious negligence on the part of a government doctor while supervising or while delegating the roles and responsibilities that his juniors should be taken care of. The third one is we came up for there should be a penalty clause that should come under the statute, wherein people who come in with unclean hands should be penalized so that this acts as a deterrence for.
Before that, there is an institution.
I'm coming to that, so that it acts as a deterrence for frivolous cases. Fourth, there has to be some kind of pre-existing system before a person can come into Consumer Protection Act. Because Consumer Protection Act should not be the first forum, we believe that there has to be some smaller or a local independent ombudsman committee that has to work in place, where certain small issues can be dispensed with and unnecessary cases should not come into court mechanisms. Then we were dealing with the issue regarding implementing the Supreme Court dictum in Samira Kohli's case. Simple consent forms needed, and that we've already discussed. Similarly, in need to frame statutory guidelines for giving disability certificates, we all are in consensus with the fact that there exists a decent, robust mechanism. We need to pay more effort to executing it. There has to be some kind of awareness and execution. A roadmap, form, as sir pointed out, has to come into place.
I think we'll have email IDs of all and we'll prepare a note, circulate it, and with your inputs to finance.
Yes.
Maybe you can all put in your email IDs here.
Registration already. Sir, would you like to say something?
About anything. I had a session earlier about I don't know about euthanasia act bill. Because when there in 2006 they came out of the second, and then at the time I said that this country needs a lot of more discussions. I think India was not prepared at that 10 years. Today, 2016, charge it. Right.
Yeah, that's
So this is gone. In fact, this is nobody now realizes that it is so now this bill for withdrawal of life support system, right? If you call it active euthanasia or passive, voluntary, all these things are there. But there is the only thing which India now, the bill is recommended is withdrawal of life support system. We don't want to call it assisted suicide. The suicide word is not, and things like suicide. So that we have to, because in India there is only right to live. There is no right to die. Like again, the issue which is that right to health is not there. It's not there in the Constitution, fundamentally. So we need to consider the right.
The second we need to realize is right to life with dignity. And that's where these patients need some kind of exception.
So when you have right to health, then it will be the government will be incumbent on the government to bring in all this, more resources and all this. And since there is a disparity between the state and the states, because health is a state issue, and some are the concurrent issues. And I say that the disparity between the private and the public sector. These issues need to be ironed out, and unfortunately last year, the health budget was cut at the center by 3,000 crores. I don't know, a lot of talk going on, but nothing much concrete to that level. So, as it is, the government spending is very meager. Added to this, when you're cutting the health budget, increase to what was cut, that's all. Whatever was cut, that was increased. 3,000 crores was cut, and this year 3,000 crores increased.
But sir, is it true that like even whatever was budgeted, I mean,
Not
significant part was not spent?
See, again the problem is, like one state like Bihar. See, you have a budget estimate and then the revised estimate. At the RE stage, in October, when you give the budget, the money to the state, you need to get back the accounts of what has been spent. In most of the states they do, but some states they don't. So, according to the legality, finance ministry is different. You have to get that certificate. Otherwise, you can't disburse second amounts. So, because of this issue, lot of money is not being spent.
So what they did, what figure told, I was working in HIV before. That's what used to happen. That in some states, Tamil Nadu used to spend 110%.
Yes.
And there are states who could not spend even 30%. Unless you give statement of expenditure, next installment cannot be given. So what they realized that a significant part is budgeted, but was not spent, so they reduced the budget. And in defense, a lot of money was required. So they shifted that money to maybe this year.
So that happens, but then you can't cut. You can't cut.
It is what's happening is even for various programs in a particular institution, say a medical college is given funds for disability, given funds for trauma, given funds for upgradation of the college. So there is a finance ministry order which says that if your utilization certificate as sector expenditure is pending for even one program, your funds are held up for all the three.
Well, and each of this is a vertical program. It's not a one comprehensive program.
Yeah, this is a vertical program. So in spite of funds being held, utilization certificate being held for one program, funds are held for the other two programs also. This needs to be. This needs to be revised to pressurize the and it is doing well. Say cancer control program is doing well, but say disability program is not doing well, and they are holding the funds and they are not doing any progress. The progress of the cancer program is also limited. So this order of the expenditure ministry needs to be revisited. That the program should be program based. This should not be institution. This is what we see. This is a major reason for which the central sponsored schemes are not going ahead. They are not progressing. Well, just for one.
So this on this withdrawal of life support, will
they say all women above the age of 35 don't have uterus in 5 months. So there are a lot of doctors surprised with them. So it's a question of integrating some property and so this follows.
There are a lot of requirements for it. See, it says it has go through a committee. See, there is competent patient and incompetent. The competent is where he is aware of his well-being. He is aware, he is aware of it. For incompetent, you have to go to the court. High court, you have to go to different bench high court. So there are a lot of issues.
And after all the guidelines, with our experience of this, kidney racket and all, if you make local SHO also the person who finally signs, so that it won't happen that doctor did not take precaution or do के बाद में सुपरविजन का इलाज है. So that's what I had written. I was telling if local Anila is also part of committee who signs, so that it won't happen that it comes back on the doctors that you did not take orders.
I don't think they will be accepting.
Because
Sir, I know. So, time hasn't come to India and a huge gap between government and private sector. Both aspects. One is a private hospital versus government hospital. And government medical college versus private hospital. Because operate as private medical colleges are easy to get approval. And they are easily getting the BJCs, BMCs, even without the basic amenities. So where it is even from the days of only government institutions are there. So that is producing so many private hospitals. And if the private medical college, I mean, that is the worst situation in this country.
So this depends on the states. The states' interest in opening out. For example, Tamil Nadu has got 22 government medical colleges, the highest mega. Private is about 12 or 13. So government, Karnataka, it has got 45 colleges, whereby majority are the private sector. Maharashtra has got
in our own state undivided AP.
We are 48.
Undivided AP. So it was only 12 colleges. So within the last 10-15 years now it has gone up to 30.
Nothing prevents the state government to start a college. Each district they need to start a college. India has got 600 districts. Start a college in all 600 districts. The infrastructure in the district headquarters hospital use that. Start a college. So that investment needs to be.
Government can start its own government colleges, but they are giving a chance to the private. Standards are very obvious.
That's
what the standards are very obvious. The patients will not be there and staff will not be there.
Again, the issue.
This is the bigger issue.
I know it was very big issue which I fought for.
Because by the name of private medical college, they are creating substandard doctors, sir, and we are at the verge of when we are falling sick. So those doctors will come and so they are finished. So who made this, and that is indirectly we hit the heart.
Now the doctor Supreme Court is taking over.
Sir, I think in this regard,
Not some changes. Lot of changes needs to be. Lot of changes needs to be. In fact, I initiated those changes as I said.
In fact, we are the ones we need more medical colleges.
That is not necessary.
It should be the government.
Exit exam is not
Medical
necessary.
college. Why private?
Why do you need an exit exam? You do a final exam, you are qualified, you do 1 year of CRI, and then you are qualified. Why do you need an exit exam?
because the standards of there are deemed universities. I had been examiner at 3 deemed universities and I was never invited the second time because they want to pass the patient. You will be paid 5,000, 10,000 per day. You will be given. I'm a tutor. Now this is not even commercialization of medical education. This is prostitution of medical education. And they come out. There is no standard. So if at least for those being universities,
You can't discriminate.
Correct.
Between
So
government and
government from government hospitals, the medical college,
created a lot of confusion. Like I can say that from the frying pan to the fire, the need was brought for national eligibility test. Already the student goes through 1 year of studying himself, and then writes an exam, 12th exam, passes it, and then goes through 2 more exams. On eligibility test. I don't understand why you need 1 more eligibility test. And the eligibility test is a central board, CBSE standard. A person studying in Orissa, state board, the person can't compete with the central board.
There is a
And
petition
in
in fact that
Orissa,
has been filed.
nothing would happen.
No, sir, recently in front of Julian Joseph it has been filed. It was went to Dave and Mr. Justice Ellen Rao.
Julian Justice Dave, there nothing would happen.
No, that's what sir. Since Justice Dave and Justice Ellen Rao are sitting together and Justice Ellen Rao was appearing when he was a counsel for. So now it has come down to Justice Julian Joseph, and we're hoping that some relief is given to these students because they've been studying in one kind of pattern and suddenly you cannot expect them.
Person studies in Tamil medium, state board, and he can't compete with the CBSE quality exam which is conducted. Only 3% of the state board Tamil Nadu they qualify. 3%. 3%. See, the intention was to have a national election so that the private medical colleges they are fleecing. So that should stop. But what happened now is the private medical colleges they were charging a fees of 8 lakhs a month a year. Now because of need they increased to 20 lakhs. Fees that is not white fees. Even today they are going charging a capitation fee. They didn't prevent the non-charging of capitation fees. They're charging 60 lakhs capitation fees, and then they increase the fees from 8 lakhs to 20. So they're very happy. So what is needed today is if the eligibility marks for the 12th standard is 60% to get into MBBS, increase it to 80%. Simple as that. Each state has got their own curriculum. So on a plan India, if you pass 60% you are eligible to study MBBS. So increase that to 80%, and then you won't get all these unqualified or not qualified, and if you have money you get into all these things. Or 85%, 90% increase it. Why do you make the student go to 1 more exam and torture him and taunt him? And this exam is where you pay 3 lakh, 4 lakh to get tuition exam. Coaching centers. Rural people, the rural students, they don't have much to remember. There's no equality in this. So this itself is completely against social equity. It's against
Everybody has been actually shocked by this.
Absolutely, and the days which is going on in this, I don't understand Mr. Dave's days. He's retiring this year.
And it's strange that he was in dissent
At
earlier.
that time, also, he got a grievance at that time. He was the only dissenter at that time.
But that Kapadia came.
I think Sadas. Last day.
Last day.
Justice Altamas Kabir. Justice Altamas
Kabir, is it? That is
They say that it was paid money by the government.
One day was that's why it's Kabir.
Justice Altamas Kabir and Justice Dave was in dissent.
But
however, now that
but for the ordinance of the state is there like
This
year it has been relaxed.
states didn't accept. But then they said that this year government is exempted only for this year. Next year all the state government colleges will come, there's going to be a big problem.
And this is an issue in lot of states where state board is prevalent, like sir said, Orissa, Tamil Nadu. Maximum people have the state boards and not
In
CBSE.
Tamil Nadu, only about 4% are the central government.
even same is true with Maharashtra.
But sir, you know that itself, sir, after this, you have a state merit, national merit. So 85% of the students who are inside in Tamil Nadu, they will be competing in the center and they will be given admission only 50% is for all India. So that's what the mix is.
No, there's still a lot of confusion in that. There are a lot of confusion in that. Already the 15% is taking to the central